Kirby, and we have Mr. View from the prosecutor's office. Officer Simmendinger was here, but he had to go. We are here today for a bond hearing. We were just here last week for an arraignment and got Mr. Kirby on the case. I know that Mr. Kirby, you haven't had a chance to talk to Mr. Taylor with any significance, but do we have a new try-by date?
Oh, I'm sorry. I was looking at his history. I will email that to you. We will have a new trial date because he's in custody. I was looking at his history in terms of talking about a resolution. So I was talking with Mr. Kirby about that.
So we've had a couple of misfires, Mr. Taylor, while you were on supervision. Really hasn't gone that well so far. Your attorney tells me that he understands that you have some pretty significant medical issues that he wants to talk to me more about once he gathers some more information. So my initial thought was we would just go ahead and set this for another bond hearing next week. I don't know, Mr. Kirby, where are we at on this?
Judge, we'd be agreeable to that. We'll get on the court's docket as soon as it's convenient for the court and my schedule.
As I'll tell you, Mr. Taylor, I am not inclined to let you out again because I don't like to work that hard. And you have been a lot of work on pretrial, not only for me, but for my people. But Mr. Kirby tells me that you got some pretty serious health issues. We got to figure out where the case is headed ultimately. So let's do that. Let's put it back on the docket for next week. Ms. Carrilco can go ahead and get you a hearing today if you have your calendars. And Mr. Kirby, you can collect all the information you need so we can talk about the furlough. You don't need to worry about filing a written motion for the furlough. We'll just talk about it.
Okay.
I mean, if you have information that you want to submit to me, you could submit it to the court by email and copy Mr. View. Okay. All right. Anything else for today?
Just, I did look at his criminal history. I know we sort of discussed a potential resolution of the case. He did go to prison for 18 months on his prior trafficking case in 2007. That was also a reduction to a lower charge as part of a plea. So what I discussed with Mr. Kirby was a reduction on the trafficking on count 1 to a third-degree felony for an agreed 36 months, and the defendant would not be eligible for judicial release until after 18 months. I told Mr. Kirby I would not go below what the sentence he received on his prior trafficking.
Okay. So we'll see everybody back here next week.
Sounds good.
All right.
So obviously it's the Ohio Revised.
I was looking at his history in terms of talking about a resolution.
I've seen your Mr. Simmons bond hearing. We were just here. The real issue in this case is the mental state of Mr. Williams at the time of the offense. Is that accurately stated?
That's correct, Your Honor.
It is, Your Honor.
All right. So, Ms. Tranter, anything preliminary to come to my attention before we get started?
The only thing in addition, we'll put on the record, Judge, is we're going to have just 2 joint exhibits. Exhibit 1 being Dr. Dreyer's report, Exhibit 2 being Dr. McGee's report. As part of those stipulations, Mr. Brenner and I are stipulating to their qualifications as experts. So we're not going to need to go into any of that as well. And we are, as the court is aware, going to be calling out of order today due to the availability of Dr. McGee. We're going to be, the state is going to be presenting Dr. Dreyer out of order today.
Okay. Anything else preliminary to come to my attention before we get started?
I don't think so.
Mr. Brenner?
No, Your Honor, and as Ms. Trancher just outlined, that is correct. Again, we're presenting these exhibits jointly, no objection to either doctor's qualifications, so we'll basically just be discussing their respective findings.
Okay. Opening from the state?
Judge will waive opening at this point.
Opening,
Waive
Mr.
opening as
Brenner?
well, Your Honor.
All right. We will call Dr. Dreyer out of order.
Yes. I do that all the time. I can't.
Just heard from the testimony of the proceedings made for both of them.
All right, Dr. Dreyer, the way this is going to work today is, and you probably already heard a little bit of this, the parties have already stipulated to your report and to your qualifications. So that means that your report is going to come into evidence, which means that the attorneys are not going to ask you everything that is contained in your report. I've already read it a couple of times, as recently as yesterday. So everybody's pretty familiar with that part of it. We're just going to highlight some issues. Do you understand all of that?
I do.
Go ahead and state your name, occupation, professional address for us.
Carla Dreyer, Dreyer. I am a psychologist. In this capacity, I did this evaluation through my private practice, Dreyer Psychological Services.
All
Okay,
right,
thank
go
you,
ahead,
Dr.
Ms.
Dreyer. Any other questions, Judge?
Nope,
I
go
can
ahead.
proceed? Thank you. Okay, Dr. Dreyer, so you did this at my request on behalf of the state of Ohio, correct?
Correct.
And can you explain to the court the methodology used to evaluate the defendant's mental condition at the time?
So I got the referral from the court. I met with Mr. Williams, explained the purpose, procedures, and non-confidential nature of the assessment process. I completed a clinical interview where I assessed his history, as well as his mental state as it relates to the offenses charged. I also looked at various pieces of collateral information, spoke with both defense and prosecution, and then put my opinion into a report that is dated April 11th, 2025.
Okay. And what was the test that you were using to determine his mental condition at the time?
So obviously it's the Ohio Revised Code 2945.371 H4.
Okay. And those what are the prongs of that?
So in the state of Ohio, they are having us assess whether the individual suffers from a severe mental defect or severe mental disease. And if so, does that prevent the individual, or did it prevent the individual from knowing the wrongfulness of their behavior at the time? So
Okay.
some people consider it a 2-prong. I see it as a 3 because we have the defect, disease, and then the wrongfulness prong.
Okay. And you said that you reviewed some collateral information. Page 2 of your report lists some information that you reviewed, correct?
Correct.
And it looks like you reviewed the report from Dr. Nichting regarding his competency to stand trial, correct?
Correct.
And there was also some competency restorations reports from Summit from Dr. Sutton from October and December of last year, correct?
Correct.
And did you also review the report of Dr. McGee that was dated February 14th of this year?
I have one from dated April 14th. Oh, in my report, I'm sorry, I put the wrong date. Yes, February 14th.
February 14th. Okay, that's an error in your report, right?
Correct. I
April.
apologize.
I
put
was
April.
looking at that last night, wondering where we got April from. So it was February 14th. You reviewed that report, correct?
I did.
Which is Exhibit 2, Joint Exhibit 2.
Correct.
Okay. And did you notice in that report that she believed that the defendant didn't have knowledge of the wrongfulness of his acts as a result of a severe mental illness?
Correct.
Okay, she used the word illness.
Correct. That's my
Correct.
recollection.
And you in your report stated a severe mental disease, I believe.
Correct.
Okay. Is there a distinction between the two?
There may not, but in the statute, I try to use statutory language. So the statute specifies severe mental disease for the insanity statute. They are asking us to look at essentially the same thing as a severe mental illness, but I do use the statutory language.
Okay. And you also had access to video and audio recordings
Yes,
that related to the case, correct?
correct.
All right. Can you tell us what of those did you review?
So the audio and, you mean the audio and video
The
portion?
audio video recordings.
Okay,
that
so there
were
there was video, not just of the defendant's interview with police, but also of the offense. I believe, if I recall correctly, there was some, maybe a ring, I don't know the brand, but there was some type of camera at the victim's home.
like a
So-
surveillance type.
Surveillance camera. I would call it a ring camera, but I don't know for sure. And so I did see that portion, particularly when he left the home.
Okay.
And so there was some audio and video of the actual offense or portions of it, as well as his interaction with police.
Okay. And was it important to you to view the ring camera footage or the surveillance footage, whatever we're going to call it? Was that important in your evaluation of him?
I thought so. I mean, it was provided to me. I review all information provided. Sometimes it's not as relevant as other information. In this case, it was helpful.
Okay. How was it helpful?
It helped me understand the scenario and what was happening, as well as his demeanor, and in terms of the surveillance video. So I was able to more appropriately picture what had occurred, but also see how he interacted with the victims that were there.
Okay. And how about his police interview? You had an opportunity to review that as well?
I did,
Okay. And was that important to your evaluation?
yes.
And what was important about that particular piece of?
Sometimes when we review collateral, sometimes police investigation notes will be very similar to what happened in the clinical interview, or I'm sorry, not the clinical interview, the interview with police. But it's also helpful to look at that to understand what the individual said, what questions were asked, how they were behaving. And so in this case, I was able to observe him prior to the officers coming in the room, and get an idea of his behavior then, but also to hear the questions that were asked, and to hear him deny being at the victim's home, being in the car in question, and refusing to give his DNA sample.
Okay. And did you also have an opportunity to view the police interview that was held with his mother, Sharon Williams?
I did.
Okay. And was there anything important about that?
So yes, she was there, and then at some point, the maternal grandmother of his daughter was present, because I think she came to get the granddaughter, and they spoke in the room. So it was helpful for me to hear them speak, but also to hear his mother talk about what had happened that day.
Okay. And how about the victim, Dr. Alan Altman? Did you have an opportunity to listen to his interview? I don't think his was video recorded.
I don't think his was video recorded,
audio.
but it was audio. Yes, I did.
Okay. And what about that, if anything, was important to your evaluation process?
He explained what had occurred step by step, and he was pretty articulate. So that was helpful to understand all of that information.
Okay. Now, did you consider any aspects of the defendant's mental health history in your evaluation?
Yes.
And was there anything that was relevant about that to you?
So the defendant had not been identified with mental illness or any type of mental health issues necessarily prior to the offenses charged. There was some indication he had hit his head, but there had been no treatment, no identified specific symptoms per se related to that. But he was identified as being mentally ill after his arrest, and he was, as the court is aware, found incompetent and then completed competency restoration. So by the time I saw him, he had already completed some treatment, was in treatment, still at the jail.
And that diagnosis happened at Summit, correct?
Correct. So he was assessed by Dr. Nick Tang, who then indicated he was incompetent due to mental health issues or psychiatric instability, and the hospital diagnosed him with an unspecified psychotic disorder.
Okay. And what does that mean, an unspecified psychotic disorder?
So there's different types of psychotic disorders: schizophrenia, schizoaffective disorder, delusional disorder. Unspecified means that it's unspecified, so it doesn't necessarily meet criteria for what we would consider to be a severe mental illness per se, in terms of schizophrenia, schizoaffective disorder, delusional disorder. It also may mean that the etiology of the symptoms are unclear. So for individuals, for instance, that have maybe their symptoms are substance induced, they'll often say unspecified psychotic disorder. If it's not really clear where they came from or why this is happening, but again, not meeting the full criteria for the other disorders. That's why they would diagnose unspecified.
Okay. And what about the suspected substance abuse? Do you have any information on that?
So there is an indication he has previously used marijuana or cannabis, and nowadays people use it in various forms. He had suggested he had not been using it prior to the offenses charge. His mother had made some comments to police suggesting that he had been using marijuana in some form. But when he was arrested and taken to the jail, your jail here, Warren County, does not, that I am aware of, do urine screens when they come in. There are some other local jails that do, for instance, Hamilton County, Montgomery County jails. But so there is no documentation to confirm if he had any substances in his system.
Okay. Did you review other medical and intake records from the jail?
Yes.
Okay. Did you have any other medical documentation relating to the defendant that you were able to review?
Medical documentation?
Yeah. Did you have any like history of medical records from him at all, other than what you received from the jail?
No, I had the jail, and then I had the information from Summit that would have been contained in the competency restoration report from Dr. Sutton,
Okay.
and as well as the letter, I think, for force meds.
Okay. And you indicated in your report, and you testified earlier, that there was some indication that he had received a head injury prior to the incidents that we're talking about.
Yes.
Where did that information come from?
He indicated he was working for like a construction supply. He would know how to describe it better. Company, and he was carrying, he said, a large sheet of drywall, and it fell on him. And he said that he hit his head, that he may have lost consciousness, but he did not seek any medical treatment. His mother also told police that she had heard he hit his head at work maybe a week or so before this. She described some changes in his behavior, but it was not clear if he had a brain injury. There was no documentation to suggest that that had been assessed, and there was no indication of a neurocognitive disorder.
Okay. So this head injury was self-reported,
Correct.
basically, nothing, no medical documentation to back it up. Did you consider the potential head injury in your evaluation?
Yes.
Okay. How did you consider that?
Well, I had to determine if he suffered a head injury and had any type of after effects from that, but also looking at if he qualified for a neurocognitive disorder, which would be related to a head injury. There was no indication of that. He did have, obviously, mental health issues. It has not been clearly indicated that that would be related to the head injury.
Okay.
If a head injury occurred, we also don't know how severe the head injury was, because we don't have the documentation, and he wasn't able to articulate some of that. But there was no indication that he had significant deficits per se afterward, although we know that he was potentially developing these psychotic symptoms.
Okay. So do you have after all of that, do you have an opinion to a reasonable degree of psychological certainty as to whether the defendant suffered from a severe mental disease at the time?
Yes.
Okay. And what was your opinion?
It was my opinion that he did suffer from severe mental disease at the time. The documentation was quite clear that he had symptoms of psychosis that had started probably before the offenses, occurred during the offense time frame, and afterward.
Okay. And that is in line with what Dr. McGee found as well, correct? She determined he was affected by a severe mental disease as well, correct?
Correct.
Okay.
Yes.
How about the mental defect prong? Did you consider that?
Oh, yes. So a severe mental defect is typically an intellectual disability of some sort, and that did not apply in Mr. Williams's case. There's no indication that he has intellectual disability, which would be substantially below average intellectual or cognitive functioning, as well as adaptive behavior deficits related to that.
Okay. So after that, then we're moving on to the second or third prong. And did you have an opinion as to reasonable degree of psychological certainty as to whether he had knowledge of the wrongfulness of his actions?
I gave the opinion that he did have knowledge, he knew the wrongfulness of his behavior or actions at the time.
Okay. And what specific evidence led you to conclude that?
So this is, I think, a complicated case for the court in the sense that we know that Mr. Williams has mental health issues, that he was ill at the time. But the next prong requires that I find data that indicates if he, to suggest that if he knew the wrongfulness of his behavior. You can't just assume that because someone is mentally ill, therefore they don't know the wrongfulness of their behavior. Many people are very ill at the time they commit an offense, but yet they know it's wrong. There may be an irresistible impulse component, but in the state of Ohio, we have a very strict insanity rule. It's in line with the McNaughton criteria. And in this particular case, I did not find evidence to suggest that he did not that he did not know the wrongfulness. In fact, there was evidence he disguised his appearance when he went into the individual's home.
Let's talk about that. What is that? What was the evidence that you considered in that?
So the victim, the doctor at the home, had indicated that Mr. Williams came in with like a hoodie that was pulled up over part of his face that obscured his facial appearance. And so that would suggest that perhaps he was trying to avoid being recognized or to be apprehended. He also fled that scene, as we are aware, and later on fled from police when they tried to stop him. So that behavior would also suggest that he was trying to evade police, was trying to avoid being arrested because he knew it was wrong. There was no other data to indicate that his decision to flee was rooted in a psychotic belief system. So for instance, I do have some people that will flee because they believe the police are part of a conspiracy and trying to kill him or kill them. There was no data to support that in this case. There was no statements made and there was no information to that effect. Once he was stopped by police at the McDonald's, he did cooperate and was later questioned. And when questioned, he also denied being at the victim's home when he was shown a picture. He also denied being in that car, even though it was the car that he said it was a car that he had been driving for hours prior to that, and it belonged to his mother.
Okay.
When police asked him if his DNA would be found in the home, he said no. They then asked for a sample, and he declined that. So he was coherent when he was making these statements and declining the DNA sample, which again would suggest that he knew what he had done was wrong and was trying to avoid responsibility for such.
Okay. Okay, and you've already stated you had an opportunity to review Dr. McGee's report, correct?
Correct.
Okay, can you explain to the court how your forensic evaluation process differed from hers based on that report? Well, let me ask you this. You and Dr. McGee, have you discussed your opinions or reports?
No.
Okay.
I haven't talked to Joy in a number of months.
Okay. Then back to my other question. Can you kind of lay out what you did differently than her?
I think, well, part of what would be obvious to the court is that we used a different format. This is, she used kind of we in the forensic world, we call it a restructured format. But so she was maybe hitting more of the, not doing as much of the background detail, but maybe hitting the specific questions or prongs of the court process. I noticed that I don't know, she didn't have a very large collateral section, so I don't know why that was. So it wasn't clear to me because based on the collateral she wrote, it didn't have a lot of the data that I found. So I'm not sure if she was aware of some of that. A lot of it would have been contained in the video, but she said in her report, she had the audio and video. So I assumed that she looked at it. But I think that was different. I do think the biggest issue, I think, in the court is probably already figured this out, is that she and I both believe that he has had a severe mental disease at the time. The issue is the wrongfulness prong. And I believe that, again, we are very strict in Ohio. I cannot make the assumption that just because you were mentally ill, therefore you did not know the wrongfulness. I have to have data. It's an affirmative defense. And I think that's where she and I differ in terms of our opinion. I think that she was suggesting that because he was ill, therefore he did not know the wrongfulness, but did not have necessarily some of the data to support that.
Okay. Okay, Dr. Dreyer, I don't think I have any further questions for you, so I will pass the witness, Your Honor.
Mr. Brennan?
Thank you, Your Honor. Okay, Dr. Dreyer, Major Brenner, Mr. Williams. Just a couple of questions for you. So obviously reviewed your report and we just heard your testimony here. You had indicated that there's evidence that he disguised his appearance.
That was what the victim said, yes.
Okay. This incident took place in February of 2024. Is that correct to your recollection?
Let me double check. Yes, it occurred February 4th.
Is it possible it's just cold?
It is possible that it was cold. It also is possible that he was trying to obscure his appearance as he walked into the home.
Sure. You indicated that Mr. Williams denied being at the victim's house, denied being in the car.
Correct.
Right. And you indicated that you believe that that's him being evasive or deflective with the police. Is that correct?
Yes, that I don't know, deflective would be the word, but yes, that he was denying that he had been there. Yes.
Okay. Is it possible due to his severe mental disease that he was just delusional and didn't know that he had been in the car or been in that home?
But he told I have problems with that thought because I did consider that. But when you review the video, he is logical, coherent. He's discussing things with them. There was no evidence of delusions in his conversation with them or active symptoms of mental illness at that time. And interestingly, he told them that he had been in his mother's car driving around. So he identified what he had been doing, yet then he said he did not, had not been in that car. So one could say that maybe he was delusional, but again, it speaks to for me, it suggests that he did not, he was denying involvement in the sense that he was trying to avoid responsibility.
You indicated that he fled from the residence. Is that correct?
Correct.
Was he asked to leave by his mother? Do you recall that detail?
My understanding is that his mom came in and told him that let's go. They then got in the car and that's when they were backing out. And from the video, you can see the victim's, the doctor's wife, and then a neighbor trying to kind of stop them. And that's when he ran over the man's foot, I believe, or hit him in some way.
So is another interpretation of him leaving the residence, he was asked to leave by his mother and he just did what his mother told him?
It could be, but yes, it could be. It also suggests, though, that they were leaving because they knew that something was wrong, that he was doing something wrong. He was able to follow her commands, and so that would also suggest that perhaps he was able to think more logically than one would anticipate if you were markedly ill.
Isn't another interpretation that his mother knew it was wrong, but Mr. Williams himself did not know what they were doing is wrong?
For fleeing the home?
Yes.
I don't know why he would still get in the car. I mean, I guess that could be one interpretation, but he still followed his mother's command and he is the one who was driving and he took off. If you watch the car come out, he's going at a high rate of speed. He is reckless. He is trying to get out of there as fast as he can. And then later on, did not stop for police when he was signaled.
And you discussed that there's a lack of documentation for the head injury that is reported to have occurred at some point prior to this incident.
Yes.
And your understanding is that's because Mr. Williams did not seek medical treatment for that?
That's my understanding, yes.
Do you have any indication or knowledge as to when that took place?
Yes, I believe, let me look at my report real quick. I thought he told me it was about, I want to say a week beforehand. He said it was the day before the offenses charged. His mother, I think, in her interview may have said it was 8 days. Maybe that's where I got the week. Yes, on page 9, she says that he hit his head about 8 days before. He told me it was about 1 day.
So at some point, pretty shortly before this incident, he at least reported, and his mother reported, that he suffered some kind of a head injury at work.
Yes, he indicated that he had been hit on the head with a sheet of drywall.
Okay. And to your knowledge, there was never any kind of testing or imaging done or any kind of follow-up evaluation there?
No, it's my understanding from him, and there was no indication to the contrary that he did not seek medical treatment. So there was no imaging or no assessment of that.
And you interviewed him in March of this year, correct?
March 31st, yes.
So fair to say, well over a year after any kind of head injury he would have suffered at that point.
Correct.
And you indicated that there had not been any kind of diagnosis or identified mental disorder before this incident. Is that right, to the best of your knowledge?
To the best of my knowledge, yes.
And at any point, did in any of the materials that you reviewed, his interview, his statements at the time of the offense, did he apologize?
Apologize to?
Anybody?
I don't recall him apologizing to anybody.
Okay. And you indicated that he denied being at the residence.
When police questioned him after they arrested him, they showed him a picture and said, "Were you there?" He said no.
Okay.
They went through that process again, and he still said no.
Okay. Denied being in the residence, denied being in the vehicle as well.
Correct, when he was shown a picture of it.
And when you interviewed him, did he have recollection of this incident?
He told me he could remember up until like the beginning portion of the day and what had happened. He does not remember this part of it, what I call the middle part of the offenses, and then he remembers being arrested at McDonald's.
Okay. And you indicated that since this incident, he's been under doctor's care?
At the time, I haven't seen him since March 31st, so I don't know, but so you have to ask him. But when I saw him, yes, he had been restored to competency and was still taking medication at the jail at that time.
So he was prescribed medication?
Yes, there was a forced medication hearing when he was sent for competency restoration.
Okay.
And I believe he was,
Go ahead, I apologize.
and that's okay, I think he was taking Abilify and then Cogentin. So Abilify is an antipsychotic with mood stabilizing properties, and Cogentin is a medication that's used to combat the side effects of that.
And at least as of the time of your interview with him on March 31st of this year, was he taking those medications still?
That was my understanding. He did not want to take them. However, when they were forced at Summit, he agreed to take them orally because he did not want to get the injection, which is what would happen next.
Just a moment, Your Honor.
Sure.
Is there anything else you can mention? Your Honor, I don't have anything else for this witness.
So, Dr. Dreyer, here's my sort of oversimplified analysis of this. So, you and Dr. McGee both agree that he suffers from a severe mental either illness or disease, right?
Correct.
And you both agree no prior issues regarding his mental health,
Correct.
and that you both acknowledge that there was reports of behavior changes after the drywall to the head incident, right?
Correct.
Do you both agree that he had confusion, disorganized thinking?
I do believe that there is documentation that his mother had suggested that he had some disorganized and thinking confusion that was documented in records.
Okay, so at the time of this offense, do you believe that he was suffering from confusion and disorganized thinking?
I think he was suffering from symptoms of psychosis, I think that, as you know, those can change and they're not there the entire time. They may also wax and wane. I do believe he was suffering from a psychotic illness at the time. What that would have looked like, the documentation that I've reviewed, there was no indication of significant confusion in that piece of it, but that had been reported, yes.
So then you agree that he was delusional at the time of the offense, right? Or do you disagree with that?
I don't know if he was delusional or not. I know he had psychosis. So psychosis can take the sense of having problems with delusions, auditory hallucinations, visual hallucinations, disorganized thinking. If you look at him in the video of the interview, I mean, he is engaging in some unusual behavior that would suggest perhaps he's responding to internal stimuli. And we know that after the fact, he was identified as being mentally ill. So I do believe that it's reasonable for me to say that he had a severe mental illness at the time. What the specific symptoms were, there is some suggestion he may have been disorganized, delusional, confused. The issue for me then becomes, did that prevent him from knowing the wrongfulness of his behavior? And so I can't just assume that it did. I would have to find data to support that.
So if you were to accept the fact that at the time of the offense, that Mr. Williams was suffering from a delusion in which he believed that residence belonged to him, if you accept that as true,
Okay.
what effect, if any, does that have on your opinion?
See, this would be complicated because, and this is not a clean cut case in the sense that if he thought
That's why
that
we're
was,
here.
yeah, that if he thought it was his house and he went in, that piece of entering the home, he may not have known the wrongfulness of that. But the fact that he fled in the way he did not stop from
We'll get to
police.
that in a minute.
No, but what I'm saying is that it's hard for me to separate these offenses. They all happen one after the other. He made that statement when he went in, is my understanding, that this was his home. He also then told his mother that it was a pervert who lived there. So I don't have consistent statements with regard to that. And when he met with police, he did not give any statement to suggest that he owned that home. So that was only what was said to the victim. I think that if I had more data to suggest that he was under the delusion that he owned this home or that he had a right to be in the home, I would need more than just the one data point because I would need to understand how that would impact him.
Okay, so let's back up a little bit.
Oh, sorry.
That's okay. What I'm asking you to do is not to analyze the data points, okay? What I'm asking you to do is accept this hypothetical. If we are to assume as a fact that he is delusional and at the time of the delusion, he believes that is his residence. If we accept all of those facts as true, what effect does that have on your opinion?
For the incident where he went into the home, I guess I would have to consider if he thought that was his home and that was his delusion, that he did not know the wrongfulness. If in fact that was the hypothetical that you're giving me, would have to say that particular incident when he entered the home or that offense, he would not have known the wrongfulness. But I don't know that I can then extrapolate. You don't want me to go forward, but you can't extrapolate to all the others to say the same thing.
That's what I'm going to get to next. So then you told me a minute ago that a psychosis sort of wax and wanes, comes and goes, right?
Well, it can change over time. So some people have a delusion and their delusions can be fixed, obviously. But when you were asking me about like disorganized thinking and confusion, we know that sometimes people can be more with it than other times. So we do know that there can be some mental status changes within an episode.
So if, for example, we're still accepting the delusion that it is his place or he had the legal right to be there, however you want to phrase that, if we're still accepting that part is true,
Okay, hypothetically.
then we'll start with possible. Is it possible then that psychosis would wane to the point where when he is interviewed by police or when he talks to people and they say, you did this, this, and this, then he would recognize, oh, that's not wrong after the fact and react accordingly. Am I wrong about that?
Wait, I lost you at the last
Okay,
part. Okay,
so
so
let me-
you're
let me-
saying that when he
Hold
meets with
on,
the
let me
police.
be more clear. So we're accepting the delusion, okay.
I'm there.
and then we're accepting the psychosis at that time.
Correct.
Then after a short period of time, when that delusion or that psychosis wanes a little bit, if it does,
Okay.
then is it possible that that provides an explanation then that he says to himself, oh, this has been told to me that I did this, that I went into somebody else's house. That's clearly wrong, and then react accordingly. Does that question make sense to you?
I think so. So to clarify, you're asking me that like when he met with police, was he then no longer under the delusion that it was his home, and therefore that's why he lied to police?
Or is it possible that he is no longer suffering from that delusion?
I guess it could be possible. It would be really unusual
Okay,
in that
hold
short
on.
period of time.
My first question was possible,
Mhm.
and then my second question is, how likely is that?
Not very.
Okay.
I mean, normally if you have a delusion, when I say it changes over time, it doesn't change minute to minute per se. But people have delusional belief systems that typically stay in place. What I see more changing is potential for disorganized thinking, particularly with stress. When individuals who are psychotic get additional stress, they may start to get more scattered in their thinking. And that's what we see. And so perhaps I should have explained that better when I talked about it earlier. But I think it'd be pretty unusual to have a delusion that you had an hour or two before and suddenly it's gone. If in fact it was a delusion, because it's a belief you had and you had not had treatment in those hours. Does that make sense?
It does, and so it's my understanding that, and tell me if I'm wrong about this, confronting someone who is delusional with the fact that their delusion is false doesn't help, right?
It depends on how you confront them, but yes, a lot of times it does not. I think that delusional individuals often have to, you have to help them look at, the information that would support the delusion or go against the delusion. That's typically how you address that with them. Just telling them that's delusional is not going to help them.
Okay. I had another question. Hopefully I will think of it while Ms. Tranter does her follow-up questions, if there are any.
I just have one follow-up question, well, maybe two. I won't lie. So you never actually,
Ms. Tranter, can you hold on for just a second? And Doctor, I don't want to be disrespectful. I have to stand up for just a minute. My apologies.
Oh, I thought you suddenly had the big question in your head.
Oh, I just need to stand up for a minute. Okay. Don't laugh.
you good, Judge?
Don't put that on the record. Go ahead.
You never actually had an opportunity to speak with the defendant's mother, correct?
No.
Okay, you made efforts, but she never returned your calls or something along the line.
I called her and I was not able to get a call back.
Okay, but you see in Dr. McGee's report that she did speak with the defendant's mother, correct?
Correct.
And on looks like page 7 of her report, she's going over the fact that mom did not report any unusual behaviors or delusions that the defendant was exhibiting until he came back out of the house and said there's a pervert, right?
Correct.
Okay,
However,
so-
it wasn't clear that his statement about there being a pervert and there was a delusion. I'm not saying that the victim was a pervert.
Sure.
I'm just saying that
That was
statement in and of
mom's
itself.
sort of, do you interpret that as mom's sort of thought at that point, like, oh, something's weird. Something's a little off here. for him to come out
Dr.
with.
McGee's report just said that when he exited, he made unusual statements about the victim being a pervert.
Okay. And from what you know about the case, based on the data, mom had been with him for a significant amount of time, correct?
She'd been with him all day, all night. She did not report any observed hallucinations during that time frame, no delusional thinking. He was clear with her. At one point, he was getting confused about where he was driving. They did not have GPS, is my understanding, because he left his phone at home. Hers was dying. And when she asked to take over driving, he told her he wasn't going to do that and that she could get out of the car if she wanted.
Okay.
That was what I remember from the information, but there was no indication from her that he told her, hey, this is my house, or made any statements that would be delusional in that regard. That was only something that was said by the victim when he went in.
Okay. And as what we know about the case, they're not from around this area, correct?
No, I believe they're from like Columbus area.
Okay. So, and the defendant has indicated in your interview, in Dr. McGee's interview, that he was using GPS because he didn't know the area, correct?
Correct. And nowadays we're all, maybe not you, Judge, but we're all very dependent on GPS. Do you know what I mean? I don't know.
I do know what you
I don't
mean.
want to make an assumption, but I feel like I can't get anywhere without GPS nowadays.
Agreed. So that's not an unusual thing in this day and age.
No.
To be using GPS. And there's some indication in his statements as well that the phone died and he actually stopped to try to charge the phone, correct?
Correct. So
Okay.
I believe they stop like at gas stations or convenience stores.
Maybe a UDF, maybe a McDonald's, that
I
kind
didn't
of
say
thing.
what they were, but yeah, it sounded like when he was identifying them as gas stations or convenience stores.
Okay. So that can be interpreted as him knowing, basically, I don't know where I'm going. I need my GPS, so I better stop and get the phone charged so I can figure out how to go wherever I'm going. Is that a fair statement?
That's what he told me he was
Yeah.
doing. Yes.
Okay. So is that delusional thinking in any way, or is that, in
No.
your opinion, like a logical train of thought?
A logical train of thought. If you are lost, you want to
You're lost, you want to figure out where you're going, correct?
correct.
And in his statements and interviews as well, he said that he drove into this neighborhood looking to ask somebody for directions.
That's what he indicated.
Okay. And again, would you interpret that as a delusional train of thought?
No.
Okay. I think that's all I have. Thank you.
I did think of my question before I forget it again. So we have 27-year-old with no history of violence, mental illness, criminal behavior, going forward beyond the 8 days.
No. He has a
What's-
history of contact with the court system as a juvenile and violence there.
Okay,
That's the only exception I make
all right. So we have violence as a juvenile, not as an adult.
that I'm aware of. Yes.
Okay,
We had an incident in Hilliard, which is like a suburb of Columbus, where he was adjudicated for robbery.
okay. And then we have an incident that is, we'll call it a period of psychosis, whatever, that is so significant that he has to be hospitalized. He's not competent to stand trial. We have to do the forced meds, all of those things. Do you have an explanation as to why that would be?
I have some hypotheses.
That's why you're here.
Okay, so one hypothesis, which would favor defense, would be that he had a psychotic break and developed mental illness.
But
And
does that
so-
happen? I apologize for interrupting.
No, it's okay. It would be unusual given his age, but it wouldn't be necessarily out of the realm of possibility. You asked me about possibilities earlier. So it is pretty common for individuals when you are mentally ill to develop your symptoms in your early adulthood. And actually, and I think I've talked about this before in court here even, but the younger you are that you develop your symptoms, the worse your prognosis is. But we know that men often become ill a little bit earlier than women. So you're looking at, 18, 19, 20 kind of thing. We also know statistically that there has been some racial differences as well. So he would be on the higher end of the age range, obviously, for him to develop a mental illness such as this. The other hypothesis would be that his substance use had triggered this, and that as a result, he developed psychotic symptoms related to his substance use. We are seeing a lot of that with the THC, particularly people using THC more freely since it has been legalized and its availability at smoke shops. And so people are not only using edibles, maybe smoking marijuana, but a lot of people will vape the THC cartridges, which have a very high potency. There actually was a recent article in literature that was talking about how they estimate it's about the cannabis that's being used now is about 30% more potent than it was even 10, 20 years ago. It's definitely different than when we were growing up per se, but we do know it's much more potent, and we are seeing people that are developing psychosis related to that. It's also possible that he took something was laced. His mother had suggested that to police, that she knew he smoked marijuana. Maybe it was laced. That's also a possibility, and maybe that triggered the psychosis. We are seeing people, though, that are developing that. So, I think it's unlikely. I don't really have a hypothesis saying that he hit his head and he developed psychosis. That would be very, very unusual. Usually if you hit your head, you're having cognitive difficulties. You may have some behavioral changes, but they wouldn't be psychosis. They would be more related to the cognitive difficulties.
To just go from being what we'll call regular folks to being severely mentally ill, that just doesn't happen usually, right?
Usually, if you're going to be developing mental illness, there's more of a progression, and people can see it over time, months, years. For it to just be sudden, raises concerns to me for substance use playing a role.
Okay. Go ahead, Mr. Brenner.
I think I have one question based off of Judge Oda, one question based off of Ms. Tranter. And so you indicated that suffering the head injury from the fall is not likely to be a trigger of these kind of mental health symptoms?
It would be very unusual to develop psychosis from getting hit on the head with like what he described. Even if you had a severe traumatic brain injury, they don't typically develop psychosis. So you see more of the confusion, memory loss, and it's much more consistent, or especially in the early recovery days.
Are you aware of anything in the literature? I mean, is it possible for that to be a trigger? Like if you're already predisposed to this kind of psychosis or what have you, that can suffering that head injury, can that be a trigger of sorts?
I'm not aware of it. I've never seen that in the literature to say that if you get hit on the head that you'll become psychotic. No, I've not heard of that.
Okay.
But I don't know everything.
I understood. Ms. Trainer asked you about seeking to charge a phone, seeking to use GPS, if that's a kind of a logical progression.
Correct.
Wouldn't it depend on what you're using the GPS for to make that determination of whether that's logical or not, right? Is that?
What do you mean?
Well, let's say you're trying to reach a dragon's lair on a GPS monitor. I mean, right? Doesn't it depend on what you're using the GPS for?
Correct, which is why I think she asked me, because he told me he was trying to get directions off the GPS. And part of his frustration that he indicated was he would stop, plug it into a charge, and he was getting impatient. So when your phone, it doesn't charge all the way or really quickly. That's what he was getting frustrated with. So he told me it was because he was trying to get directions. He didn't mention the dragon's lair or anything, but if it were, I think your question is if it were for a delusional purpose, like he needed to go find Jesus or the FBI to go report something that was illogical, then that would be concerning.
Did he indicate, he said directions. Did he indicate directions to where?
He was trying to get back home, is my understanding from him.
Your Honor, I don't have any further questions.
Just have one last project for you, Doctor. These are the stipulations that are in the case. She hasn't reviewed these, right?
I don't believe so.
I don't think so.
Okay. So there's 3 pages. You've already reviewed the police reports in the case, right?
And the audio video.
So if you could just review these agreed stipulations of fact, just read those over, because my question at the end of you reviewing those is going to be, is there anything in there that changes your opinion or
Oh,
affects your
okay.
testimony today?
Okay. I thought this was another one. I have reviewed the agreed stipulations of fact, and none of that changes my opinion.
Is there anything that you found significant to be in that statement of fact that you say to yourself, oh, I hadn't thought about that before?
Yeah, the one thing was that when it talked about how he went inside the home and Dr. Altman was there, and then that his mother opened the door and told them they needed to leave. And as he walked to the door, Dr. Altman was still on the ground, and then he kicked him in the ribs, which would suggest that mom may have witnessed that to know that there was something wrong. That just, I thought, was very interesting to me. It doesn't change my opinion, but I don't understand why the mother did not intervene prior to this or get help if she in fact thought he was as unstable as we think he may have been.
Anything else based on that?
No, Your Honor.
No, Your Honor.
All right. Thank you, Doctor.
And then, do you want these? 1 and 2?
Yeah, that's fine.
Am I good?
You're good. Thank you. All right. So we are going to continue the trial in progress until tomorrow at 10.
Yes, sir.
Okay. All right, that's all.
Okay.
Thank you.
Thank you, Doctor.
So
So the only thing I'm showing is a motion to exclude the online broadcast
Muted it and took it out.
sentencing. Are there other motions that are set?
yes, sir. There's a 404, 412 motion to eliminate, and there's another motion to eliminate.
All right.
Those were filed probably before the case was the venue change. So I don't know.
Can you hear?
All right, well, we'll,
Now again.
Well, I'd rather have some guidelines going into the trial and have an order knowing what we can ask and not ask today than during the middle of a trial, Your Honor. Ms. Clack. No, okay. Ms. Clack, yeah, okay.
Well, let me deal with these other matters because obviously your motion to exclude the live stream of any pretrial motions, and I've read through your motion. Defense have any objection to any of that? Good. What I'm talking about now is the state's motion to exclude a live stream of the pretrial motions and the trial itself. It is a public trial. We'll reserve the motions in Bucciarelli until after I've dealt with these other matters.
Yes, Your Honor.
And see where we are. All right, we have Mr. Willis. Let's deal with Mr. Willis's case. He is on screen with us. Saul, you have a motion?
Yes, Your Honor.
I've read through it. I don't know what he's asking.
Yeah. Your Honor, I filed a motion asking for actually two separate transport orders. In my motion, state I've had some difficulty. I think that's the polite way to put it in terms of scheduling a visit out in Morgan County. So I was going to ask the court actually for some assistance with that to see if we could get a transport order issued to have my client brought in for the sake of review before the trial, and then, in other words, as soon as possible, and then brought in a second time, of course, for the trial, but maybe a couple days in advance so we could do the final preparation on it. I've spoken with General Crouch. He's in a meeting this morning, but he indicated to me that he was not opposed to the motion and was in agreement with.
His trial is on the 23rd, correct?
Yes, Judge, September 23rd. Expect it probably take at least 3 days just because of the number of witnesses.
Well, we have a criminal docket here on September the 5th, correct? So why don't we have him transported here on September the 5th for that criminal docket? And then you'd have to have him transported here for his trial. Then I don't know what does Captain Davis have to say about transporting him a couple of days before trial? No, Officer Howell, if you can come up. So within the ability I have to direct the sheriff as far as transportation, I'll certainly try to accommodate your request, and I don't see there's a problem with transporting him on the 5th.
Yes, sir.
And allowing you to have that opportunity to speak to him. And then,
yeah, he's scheduled, of course, to go to trial. It's a Tuesday, 23rd. I don't know the procedural ins and outs the way TDOC does it, but I would think they would have him here at least on Monday, the 22nd, given that trial would start.
Well, I'm sure they will, yeah.
So if he's here then we could do our final discussion before then. But if he was brought here September 5th, that would be very helpful.
All right. So having him transported perhaps on the 4th for trial, for a hearing on the 5th for the criminal docket call that we have September the 5th, and then having him transported on the 22nd for his trial the next day on the 23rd.
Thank you, Judge. And I'll submit two different orders
All right.
so one doesn't get lost with the other in terms of TDOC.
Good question. I mean, I can only suggest that the order will state that we're asking for him to be transported for that purpose.
Yes, sir.
Officer Howell, Mr. Wills is scheduled for trial here on September the 23rd. Mr. Saul is asking to be able to meet with him. We have a criminal docket call on the 5th, so I was going to request that he be transported on the 4th to be here and be held for that docket call on the 5th. Is that possible? Will the TDOC allow us to keep him overnight? All right. Yeah, we're going to need him in court on the 5th, so if you transport him on the 4th, Mr. Saul will have an opportunity to meet with him either the 4th or the 5th. And then we need him again on the 22nd before his trial on the 23rd. All right.
I'll submit 2 separate orders, Judge,
Right.
stating that. Thank you, Your Honor.
Mr. Wills, I assume you could hear everything. I muted you a moment ago because we were hearing what was going on there, but we're going to bring you in a little early on the 5th, 4th, so that you can meet with Mr. Saul, then again on the 22nd, and give you two an opportunity to try to discuss your case and make sure you're ready for trial. All right, thank you.
Thank you, Judge.
Your Honor, if the court has any other business to handle beforehand, I would ask that my client being on the way, he texted me, that this be called later.
That's fine, Your Honor. The victim is actually here today. I thought she understood that we were going to reset this. She's just given birth 2 weeks ago. So I thought we were going to reset this. I'm going to go talk to her, and if she's ready today, we can move forward. If the court.
This is the 412 hearing?
Yes, sir. I did not think she was going to be here, so I'm not quite sure what's going on. So I'd ask for a little break too. If that's
All right, well, we'll pass your case and come back to it.
Thank you.
Thank you, Your Honor. Your Honor, those are my motions. We'll need to get General Sylvie for that. She's working in sessions right now, so if we
He's
could just-
working what?
down in General Sessions Court, Your Honor. So I'll have to have her come up here for this one.
Well, so we are down to the Bucciarelli case. Let me take a break. So I want to read I want to read all of the pretrial motions so that we can be sure we're all on the same page before we begin. Mr. Talbot, do you have anything? You're standing, so I wondered if you were. Well, you have the Hansard case. And General Allen has gone to speak with the victim who is here, the alleged victim who's here today. And as a result of that, they were talking about going forward perhaps with the 412 hearing. Then I've already signed your order on your ex parte motion. General Allen, what did you find out?
I haven't yet, Your Honor. I think there may have been a witness mix-up. I'm going to see if I can call our victim and see if she's here.
Well, let me step off, review the Bucciarelli information, and then we'll.
What'd she say?
No, she just sent it.
General Sylvia is now here from the dungeon. We'll go forward with the hearing. If you're ready, General Sylvia, on the motions and sheets. Right, I have before me the Assistant Public Defender's motion for a bill of particulars and the state's response, and then also the Public Defender's motion for a mandatory joinder of the two indictments and a merger of counts, and the state's response as well to that. So you may. You're wanting to amend the indictment? So do you think as a public defender, you have the standing to amend the indictment in a case? This may be a first. This kind of reminds me of the story about a guy who didn't practice criminal law. But he asked his friends, what could he do in a criminal case when he went over in front of, all he did was civil law, and he went in front of a judge on a motion And so he was asking the other lawyers who did a lot of trial work, probably Mr. Flanagan being one of them, and how he should do it. And they said, well, the first thing you do is you need to tell the judge you want to take a non-suit, which is a civil proceeding. And so now the judge is going to act like you're crazy. He's just testing you to see how serious you are about, your motions. So you just, no matter what the judge says, you just keep insisting you want to non-suit the criminal case against your client. And as a result, that guy barely avoided 10 days in jail before some of his friends finally clued him into what was going on. So I'll be interested to see what is a matter of law that the public defender, a defendant, has the right to amend the indictment, which is brought by the state in any criminal case. So it should be an interesting argument. How about it? Turn that microphone on if you're going to stand there. But
I had asked for it to be set for hearing today, but I don't know that it is on the docket.
What? The motion to amend?
Yes, sir.
Well, unless the state has some objection, I don't know that I've got it in the file. When did you file it?
Last week, sir.
Well, what I have seen thus far this morning is your motion for mandatory, your motion, the first motion that I had was the motion for the bill of particulars.
It would have been Ms. Hayes, Julie Hayes, on the 14th of August. You found it, yes.
You have a copy? Oh, okay. Sylvia, Shelby, have you seen it?
I did not respond to it for obvious reasons, but I have seen it, Your Honor.
Are you prepared to argue that motion then this morning?
I can, Your Honor, yes.
All right. I'm ready to hear your motion.
Thank you, Your Honor. Mr. Sheets, can you? All right, Your Honor, for the motion for bill of particulars, what we're asking for is the state to be required to specify the exact acts that constitute the course of conduct as contemplated in the stalking statute that the state believes are amount to the offenses of stalking that are charged in this case over 2 different days. The defendant right now is without any specific information about what specifically the state intends to prove as the course of conduct, which would need to consist of separate acts, separate non-continuous acts that evidence a continuity of purpose.
Wouldn't that more properly be obtained by the defendant through discovery rather than through a motion for a bill of particulars?
Not necessarily. The reason being, in discovery, we've received just information about some contact between the defendant and the alleged victim. And it's not clear what the state intends to prove. Is it some of these acts? Is it all of these acts? Which of these acts that are attributed to the defendant are the ones that he needs to defend himself against? These need to be identified because once they're identified, then the defense can determine whether they evidence, in fact, a continuity of purpose and whether they are separate and non-continuous in and of themselves. That's why these acts need to be defined or specified by the state so we know what it is they intend to prove and can respond to that. This is important, Your Honor, not only for litigating the issue of whether the acts that are alleged by the state are separate and non-continuous acts and whether they evidence a continuity of purpose. It's also important for double jeopardy purposes. The state needs to lay out exactly what acts they accuse the defendant of doing so we know whether in the future he's charged with being charged with the same acts. And so that would be important to be defined so that we can avoid a problem of double jeopardy. There's another double jeopardy issue in this case already, but I will address that in another motion. Will the court want me to proceed on the other motions right now, or should the state respond?
General Sylvia, if you'd like to on the motion for bill of particulars.
Filed a response with the different purposes for a bill of particulars to inform the defendant of the charge and the details against him, avoid prejudicial surprise, enable them to preserve the double jeopardy. In the indictment, we have two specific dates alleged on there. Discovery has been provided that will correspond with those dates. I answered some of the questions that he also had probably in the motion for joinder and consolidation as well. But through discovery as well as the indictment, they are well informed of what the dates are and the actions that fall within those ranges. For the separation of the two charges, which actually comes to the next motion that the defense has filed, there are legal acts that can define those two actions for two separate counts. And I have informed them of exactly which part in that legal argument would be the bringing of charges. And that's actually in the next one. So between motions, discovery, the bill of particulars is satisfied through discovery, as well as I did answer one of the questions. One of the main things they wanted to know was about the prior conviction. And in my response, I have the notice of the prior conviction, if that is a question for the defense.
Any response, Mr. Talbot?
Yes, sir. The state needs to make this election because of the way the statute is structured. They need to basically say what acts constitute which counts. And the problem is if they don't, then the counts alleged, if they don't, then the problem is that there are some things the defendant is accused of doing that will correspond, not sure what those acts would be, to count one in the first indictment. And then there will be some set of acts.
Each indictment only has one count. And I understand you've filed a motion to consolidate those two, even though they occur on separate dates. And in the state's response, they have pointed out that while they are certainly in agreement to do that, to try that if that's what the defendant wishes, that would also open the door for the state to potentially have evidence of one of those instances that would be introduced in the proof of the second instance, and where they might otherwise be excluded at trial because of the rules of evidence. So I understand what you're saying is that they need to elect, but if we don't consolidate the two, then the state doesn't have to elect as to between those two. They simply have to put on their proof and prove their case on the date that is alleged. But if they're consolidated, I understand you would want a distinction drawn between them.
And that would be That would be a concern in a different offense. However, because this offense of stalking involves it involves the state proving separate non-continuous acts that evidence a continuing course of conduct. The course of conduct language is what makes this different. The course of conduct here would, and this kind of goes into the next motion to merge the counts. The course of conduct, Your Honor, is not interrupted. The defendant's alleged course of conduct is not interrupted by any of the statutorily defined events that would interrupt the course of conduct by law and then result in there being a separate offense of stalking. Because we already know as of right now that the state will not prove an intervening event that separates the course of conduct over the days in August that are at issue in these two indictments. We already know that these have to be put together into one single course of conduct. There's no, as a matter of law, way for the state to prove that these are separate charges. They're all under one course of conduct by the statute, the way it's defined. So therefore, we're asking the court to get to that conclusion. That's what informs this request and why it's important that the state say what the acts are at issue that it believes are a course of conduct. And that's why we're asking for this. If they can say what the acts are and whether they constitute a single course of conduct, then we know what we're arguing against. Or if they say it's a separate course of conduct, we know what we're arguing against. And that's why it's important for the state to delineate which acts are under which count and whether they take the position that these are the same course of conduct or are not the same course of conduct. That's why we're asking for that clarification.
Well, the rule for bill of particulars does provide that on a defendant's motion, the court may direct the district attorney general to file a bill of particulars so as to adequately identify the offense charged. Clearly, I think the state's position is that especially aggravated stalking is identified by the terms of it. But Mr. Talbot makes a compelling argument that there's some reason that perhaps would be to ensure that the defendant has a fair trial, that a bill of particulars identifying what separate acts, if any, occurred. And I know the state in its response to one of the motions that I read this morning identified that there were certain things that occurred. And I think therefore that putting those into an answer to a bill of particulars would be more appropriate. So I'm going to grant the defendant's request. Is this case set for trial? Then let's go ahead and, how long do you think you would need for that particular response, bill of particulars? 15 days. So the state will file a response to your bill of particulars request or file a bill of particulars within 15 days. All right, Mr. Talbot, we'll move on to your next motion.
This is for, Your Honor, this is for mandatory joinder and merger of counts. I'll leave aside the mandatory joinder discussion. I think that's one where the state has no opposition to these counts being tried together, these counts in each indictment. Rather, the critical issue, Your Honor, what we probably have an argument about is merger. And I would submit that what I'm arguing to the court today is that the state it's already established that there is no intervening event as defined by statute.
How do you, excuse me for interrupting you.
Yes, sir.
You keep referring to the fact that the state has already established and the state cannot prove an intervening act. Tell me how you know, since we haven't put on a single witness in trial,
yes, sir.
How do you contend as an officer of the court that the state is simply not going to be able to do that?
Yes, sir. I look at the statute, which provides the 3 ways that a single course of conduct can be separated, alleged stalking can be separated into multiple courses of conduct. And it's defined by the statute at TCA 3917-315K. K1 says that for purposes of determining if a course of conduct amounting to stalking is a single offense or multiple offenses, the occurrence of any of the following events breaks the continuous course of conduct with respect to the same victim that constitutes the offense. Those 3 events are: the defendant is arrested and charged with stalking, aggravated stalking, or especially aggravated stalking. That is not alleged in this case.
Where are you reading? What?
Yes, sir. 3917-315.
Okay.
And that this appears in my motion for mandatory joinder and merger.
Right.
So that event we know is not alleged by the state and hasn't occurred. If the state says it has occurred, that would be new information. It doesn't appear in the discovery. I will say in candor to the court, the defendant was, I believe a warrant was taken out after the August 1 allegations. And so a warrant may have came out August 2, but he was not arrested on that, Your Honor. And that means that circumstance A is not fulfilled here. So there is no intervening event based on A. Then B, another one would be the defendant is found by a court of competent jurisdiction to have violated an order of protection issued to prohibit the defendant from engaging in the conduct of stalking. That has not happened. There are no signs that it has happened. And finally, the defendant, this is the third intervening event, the defendant is convicted of the offense of stalking, aggravated stalking, or especially aggravated stalking. So that is not alleged to have occurred. All three of these have this commonality of they are procedural in nature. They have to do with the criminal justice or civil order protection process. And it's clear already that none of them occurred. That's why the court can move on to merge these counts, because as a matter of law, the state will not be able to prove an intervening event. So therefore, it ends up being one count of stalking of some kind. That's what it ultimately ends up as. The court can already get to that. And these rules make sense, Your Honor. They're there so somebody who's accused of stalking on one occasion, who's then arrested for that stalking charge and then continues to stalk somebody, can still have another charge placed against them. So there's a good reason for these rules to be the way they are. And in this case, none of these situations have occurred. Rather, it's much more like Mr. Sheets is accused of stalking in a single course of conduct over 2 days, and it's just going to be one charge. We can already say that. And that's why I asked the court to do that. There's also some law here. In one of the cases cited by the state, in one of the cases cited by the state, the State versus Vigil case, in their response, this supports the defendant's position, because in that case, there was a defendant who was charged with, convicted at trial of 2 counts of stalking, and the Court of Criminal Appeals found that the actions of the defendant for which he was convicted in the first count of stalking had occurred from February 1996 to January 1997, over a year. And then in the second count, he was convicted of stalking for events occurring February 1997, March 17, 1997. And the Court of Criminal Appeals said that all of those are one continuous course of conduct with no intervening event. Therefore, it was a violation of double jeopardy for the defendant to be convicted on the first count for the conduct that occurred, to be convicted separately on the first count for the conduct that occurred February 96 to January 97. So here it's a similar situation, except the time frame is much shorter. Here we have what, according to the information provided by the state and all information available to the defense, this is a single course of conduct that Mr. Sheets is accused of. So we can go ahead and say this is not 2 counts. To charge him with 2 counts over this based solely in the discretion of the state is multiplying the counts unnecessarily and in violation of double jeopardy, given the way that the statute is formulated. I'll leave it at that. Oh, no, there's one more thing. The state's response said something about something emphasizing the knowledge of the defendant as far as whether he can be charged with an additional separate count of stalking. That's not relevant. That's not the criteria for whether the course of conduct is broken into 2 separate courses of conduct that would amount to 2 separate charges.
Your Honor, effectively what the defense has done is he's asked you to dismiss one of my cases. He's filed a motion to dismiss.
What he's actually asking me to do is to grant what would be in civil terms as a motion for summary judgment.
Correct.
In other words, that at this stage of the game, there's not enough evidence to, warrant the plaintiffs in a civil case being able to proceed, so therefore you ought to dismiss it as I'm entitled to judgment as a matter of law.
Yes.
That's the way I'm interpreting it.
That's the way I'm interpreting as well. I have a one count indictment. They're asking to have consolidated and merged, which is you're asking to dismiss my case outright without hearing any proof or allowing a jury to decide if I haven't met my burden. So that's mainly where we get with the motion for merger and consolidation for trial. Now, the law does state that there is to be an intervening act, which it says the initiation of process and criminal charges. And we do have that. And like he said, it is not relevant to whether or not the individual knew it. The warrant was sworn out on August 3rd, and there was additional contacts made after that, after he had been seen by law enforcement. I can, one of the deputies is available to testify about that knowledge that was shared. That is all in the discovery. They know exactly when all those dates are, but the law does say that to start and stop a course of conduct, the initiation of criminal charges, whether the defendant is aware of them or not, can be the intervening thing to separate into two different cases. Right now, or two different charges. Right now, we have them as two separate cases. And in my response, it does say, if they want to waive and consolidate them and do two counts in one trial, there's going to be a huge prejudice to the defendant that should we go forward, should a jury say, you don't have enough to meet that second case, they very well could use information on count one into count two. But if the defense wants to consolidate those for trial and run that risk, that's on them, and I will not oppose that. But I do say that there needs to be two separate counts and that there is an intervening act. And they are very well aware of that through discovery, and it does meet the law and the requirement to separate into two counts.
I'm going to rely on the statute, which says not that the initiation of criminal process breaks up the course of conduct, but that the defendant is arrested and charged with stalking, aggravated stalking, or especially aggravated stalking. There's no arrest. The state doesn't say that there was an intervening arrest. So I'll leave it at that.
Well, this court's opinion, as I kind of indicated momentarily, that the state has the right to put on the proof that they desire to in any case that they bring. The defendant does not have the right to dictate to the state how they proceed in their case, except for the fact that there are certain motions in limine or motions to suppress that allow a defendant an opportunity to address the issues regarding the evidence that's going to be introduced. If the public defender on behalf of the defendant wants to have the two indictments consolidated for a trial, then I'm going to ask that his client take an oath and be allowed to question whether or not he understands all of the ramifications of that, and states on the record that he is in agreement to consolidate those two, because it is very likely that the evidence of one of those cases and counts would be introduced or would bear on one of the other counts. And if they are tried separately, then potentially it would not have that, would not be admissible to do that. And I understand the defendant's argument that by trying to consolidate them and then make the argument that there's only one case, that he's thinks that's to the benefit of his client. But in this court's opinion, the state has the right to put on the evidence. I do not think that at this juncture that this court can simply find as a matter of law, as I would in a civil case, that there is insufficient evidence and that the state could be prohibited from introducing evidence on a particular indictment. So the motion for mandatory joinder is contingent upon the defendant's agreement under oath and on the record. The defendant's argument for merger of the counts is respectfully denied. And at the trial, just like any other case, if we try those two together, or if we try them separately, at the conclusion of the evidence, the defendant has the option of a motion for judgment of acquittal arguing that the state has failed to prove the elements of the crime. And at that point, the court can address that issue. But as far as being able to make that ruling in advance of any testimony or in advance of any evidence that the state would offer at trial, I am of the opinion that that is not an appropriate method by which this court can address the issue. So the motion for merger of counts will be respectfully denied, but your request regarding the joinder is pending before the court. What does your client wish to do? You may. You need to have a moment in private. He'll have to go into his cell, so. You know, Alan, you have any luck in determining what your situation is? I don't want to take up anything substantive without the public.
I understand.
defender,
She's,
but
the witness on Hansard is not here, Your Honor. I think she got mixed up with Ms. Clack on the other one, so we'll be getting a new date on that one. And we'll wait till,
well, when Mr. Talbot returns, we'll address the issue of the continuance.
thank you. I appreciate that very much.
I'm going to ask you if you, I know you're restricted, but try to raise your right hand to the best of your ability and let us place you under oath. Thank you. Mr. State your full name for the record.
Danny Ross Sheets, Jr.
All right, Mr. Sheets, you're represented by Mr. Talbot of the Public Defender's Office, and the issue that's before the court is whether or not to join two separate indictments alleging that you were guilty of stalking, especially aggravated stalking, on two separate occasions. Your lawyer has asked, and it's a trial strategy kind of a thing, he's asked for the court to join those two for trial. Do you understand that? So that one trial would be held for two separate indictments, treating them as count one and count two. And if we do that, let me explain to you this way to make sure that, have you talked this over with your lawyer?
Yes, sir.
Did you and Mr. Talbot talk about the advantages of doing that versus any kind of disadvantage?
Yes,
You
sir.
feel like that you understand what's in your best interest?
Yes, sir.
Do you understand, and I'm stating this on the record, even though I'm sure your lawyer has explained it to you, if we tried those two indictments on separate occasions in front of separate juries, then evidence of one of those alleged instances of stalking might not be admissible in the trial of the other, if you understand correctly. They don't want to convict, the state can't convict you in one case for something that happened in another case under normal circumstances. But if we consolidate those two for trial, then the jury that hears your case is going to hear all of the evidence regarding both of those instances. You understand that? Including they'll hear a testimony about count one, if we talk about it being the first date of alleged August the 1st of 2024. But they'll also hear, the same jury will hear the evidence about August the 5th. Now, your lawyer is arguing that those two dates should be considered to be one count rather than two separate counts, and he's made that argument to me, but I am at this point simply saying that that will be a matter for trial rather than for pretrial motions for me to make a determination about what the evidence is or is not at this stage. We haven't heard any evidence. So do you understand everything that you and your lawyer have talked it over? And do you feel like you understand everything that we're talking about?
Yes, sir.
And you understand you are waiving by agreeing to this consolidation of those two counts for trial, those two dates, then you're waiving any issue about whether or not evidence of one should come in the trial of the other count. You understand that?
Yes, sir.
All right. And I want to show that, I will, for the record, show that the defendant has acknowledged that he is intelligently and knowingly waiving any issue regarding the consolidation. And I will grant the motion to consolidate. These two these two indictments will be consolidated. The indictment charging August the 1st of 2024 will be count one, and the indictment charging August the 5th will be count two. That would be CR 153 is count one. CR 154 will be considered to be count two of that indictment of a consolidated case. All right. Thank you, Mr. Sheets. You may have a seat. Now, Mr. Talbot, you still have a motion, I believe, for amendment to the indictment. Is that correct?
Sir, and I understand that this is all highly unorthodox. I researched it closely. Is there a cognizable motion to dismiss in a criminal case? I know that these motions are somewhat in the nature of that. And in my research, I saw—
You don't raise it, it can't be heard by the court and can't be considered by the Court of Appeals. I have no issue with you making the argument. It
Certainly.
is somewhat unusual in a criminal case, but nonetheless, it's still your duty as your client's attorney to raise every issue that you believe to be relevant and appropriate. So I'm not criticizing you for doing it. I'm just saying
Yes, sir.
it's an interesting theory. So
I didn't take it as criticism. I took it as it is unusual, and I closely researched it, and I saw in, like, for example, treatises like Mark Ward's book, it was described as being uncommon, but has happened before. And so that told me that there was a possibility that these sorts of arguments might be cognizable. But once again, Your Honor, we're at with a motion for asking for the amendment to the indictment to change it from especially aggravated stalking to a different stalking offense is because, again, the nature of the argument is, as a matter of law, the state will not be able to prove a predicate conviction, a prior conviction for which the defendant might be able to be found guilty of especially aggravated stalking as charged in both of these indictments. The reason being there is no conviction, and there will not be a conviction prior to the August 1 and August 5, 2024 alleged offense dates. That time has passed, and we can't change the past. The state has responded in its response to my motion for bill of particulars, saying that the conviction they allege is a diversion plea that was entered in September 2023, I believe. And that's simply not, as a matter of law, a conviction. And so that's essentially the argument we're making. There's no other conviction on the horizon for Mr. Sheets that would qualify, that would meet that element of the especially aggravated stalking offense. And therefore, it just cannot be especially aggravated stalking. The question that might be before the court is, well, I'll save this, but we say it's not a conviction. And it will not be a conviction. It was a withholding or deferral of prosecution pursuant to a conditional plea, and no judgment of conviction was entered prior to the date of the offenses charged in the indictments.
Your Honor, the motion is to have, for the defendant to force the state to amend the indictment to the charge that they believe it should be. It is, I don't believe that is the proper motion, and amending the indictment is not the proper request before the court. I don't think there's any authority for which they can make me amend my indictment to be the charge that they insist because of a question.
The charge that they're insisting should be brought is actually a lesser included offense of the charge that the indictment states, correct?
Yes, sure.
And in the normal course of criminal proceedings, a defendant goes to trial. If there's proof that establishes it is a lesser included offense based on the facts, then the state and the defendant can either agree or they can submit it to the jury, and the jury can make an evidentiary finding one way or the other.
Yes. So now defense counsel and I have a question of law that we have discussed regarding the prior conviction. That is not what they are filing and asking the court to do. And I don't think it's fair for the court to hear it without arguments and research and things like that for the court to consider. Asking to amend the indictment doesn't answer the question of law that exists regarding the prior conviction. The defense is well aware what the prior conviction is, but asking the court to amend the indictment doesn't allow the court to hear what the argument about the law is prior to trial.
Well, I'm not aware of any law, period, that allows a defendant to request and require the amendment of an indictment. There are motions to dismiss, motions in limine, all sorts of motions the defendant has available to them. And by denying this motion, I'm not denying the defendant an opportunity to raise the issue in an appropriate motion, but it is this court's opinion that a motion to amend the indictment, that the defendant lacks standing to bring a motion to amend an indictment. An indictment is an action of the grand jury of this county. And while the state has the right to amend the indictment as the prosecutor in the case, they require the court's agreement and a court order that allows them to amend. So for all those reasons, it is this court's opinion that I don't believe that the motion is proper because the defendant lacks standing. In addition to that, as I pointed out, the charge that the defense is arguing should have been brought in the indictment rather than the charge that is brought, which is a lesser included offense, and that's normally something that we include in the charge to the court, to the jury rather, and the jury is allowed to consider that, and they make their determination based on the evidence. But if it is such a compelling issue that at the close of the state's proof, the defendant argues that there is no evidence to support the finding of especially aggravated kidnapping, especially aggravated stalking, then they have the right under a motion for judgment of acquittal as to that charge, and the court can and might consider and grant that motion, which would then take that issue away from the jury, and they could only consider what the court found was the evidence in the case. So,
yep.
I agree. I understand your argument, but I think that's the proper way to handle it. So. Anything else then in this case? And we don't have a trial date yet, is that correct? Any reason we can't set one? General Sylvia, are you ready to set a trial date? Well, let's just pick a day on that day if you want to, or I can give you we can potentially look. I'm back here in, when am I back here? We're in January. And we can give you a trial date on I have given out criminal trial dates of the 13th, 14th, 15th, 16th. Then I have the conspiracy cases, the multiple defendant conspiracy cases that are set, if we can find a venue, for the 20th through the 23rd. You want to pick one of that first week, the 13th through the 16th? General Sylvia, is any of Talbot, you have an issue? I showed that we have Greer on the 13th. What is the charge in Greer? That was my question. That's your client. Let's set this case on sheets on the 14th. Is that suitable? Right. January the 14th is the trial. We'll leave it set for status on Monday in case there's any other issues. It'll be Monday, the 22nd. Is that correct? You want to just put him on September the 5th since we have a criminal docket that day. That'll try to lessen the burden on that 22nd. All right. You're welcome. You know, Sylvia, you're going back to the dungeon. What does that leave us? All right, State versus Gregory, Arnie Hansard. Miss Allen, General Allen, you had indicated that at this point you are not going to be able to proceed. You wanted to move for a continuance.
Yes, Your Honor.
On your 412 motions, do we know a time frame for when your victim in the case or the alleged victim in the case would be available?
Well, we currently have a trial date, Your Honor, of September 24th and 25th. I hate to put a newly postpartum woman on trial for something that involves trauma. If we need to move forward that day, we can. But just whenever I would at least like to give her another week or two.
When this case goes to trial, how long do you expect it to take?
Maybe a day and a half. I think picking a jury will probably take the longest, but I would want to block off 2 days just to be.
And how long after, of course, she's given birth, so it's just a question of how long does she need to, how long are you requesting to put it off?
I would just ask maybe December or January.
Well,
I don't know what the schedule is.
I want to make sure we're on the same page about
I'm
what we're
asking-
talking about. There's a issue of when we're going to hear the 412 motion. And then there's an issue of when the trial is. And I can say with the 412 motion, anytime prior to trial will be fine. I understand the medical needs.
Yeah, we're going to first determine when the trial might be, and then we're going to, does the state have any, does the defendant have any objection to continuing the trial in view of
Yes.
all right, no objection, then the motion to continue the trial date will be granted.
Yes, we do object to the.
Oh, you do object?
Yes, sir,
All
I
right.
misspoke. My client is eager to have this done, so we ask that the trial date stay where it is.
All right. When does she give birth?
She gave birth on August 2nd.
And the trial date is set for the 24th.
Yes.
September the 5th. for the motion?
Sorry.
That day?
Yes,
Okay.
sir, I'm sorry.
I
I
didn't
was
know if you were
putting it in my calendar.
checking
No.
your calendar or
Sorry,
responding.
I'm sick,
to-
Your Honor. I'm sorry. I'm a little dazed.
If you were on Facebook, I didn't want to interrupt or whatever. So.
Oh, yeah, I'm just cruising the interwebs.
All right, September the 5th for the motion, Rule 412 motions, and then we'll keep the trial date. Currently, we'll keep the trial date of the 24th.
Sir.
We'll see whether or not any other issues arise.
Thank you.
It may require a medical proof to get a continuance if there is an issue. So
It's not really a physical thing, just a psychological thing.
I understand that. Then that brings us to the last case, which is State versus Patrick Victorelli. I have reviewed the file and the various motions that have been filed in this case, and it is my opinion that this court has, for a long time, conducted our proceedings and broadcast them on YouTube as a live stream in an effort to have transparency for what takes place in this courtroom because it is a public proceeding. There are certain limitations that I have observed and followed in the broadcast. Those include where testimony of a minor child would be involved. We don't broadcast that. Where there is testimony regarding the mental health issues of a minor child, and we do not broadcast that. Certain cases that involve sexual offenses, this court has leaned towards not broadcasting those matters, so that and the reason that we don't is because, as was pointed out in the state's motion, while I put my live stream out there for the general public, there are other individuals, other channels. I don't have any idea who they are. Our channel is free. We don't make any money. It's a nonprofit thing. But there are other for-profit channels apparently who acquire certain of our hearings and rebroadcast them. And there, unfortunately, we have a community standard on our broadcast of individuals and comments that are made. We don't allow inappropriate comments to be made. When some other channel acquires one of our hearings or a trial and they put it on their channel, they don't observe the same type of standards that we do. And as a result of that, there are some pretty unfortunate things that get said and done about me. I don't care about me, but about the litigants and the lawyers. And I regret that that is the case. Judging all of that, it is this, having reviewed this file and the nature of the case, it is this court's opinion that this matters, including all pretrial hearings, should not be live streamed. And therefore, I'm going to instruct that the live stream today be terminated so that we can then take up these pretrial motions. I do that for the protection of the defendant, who is presumed to be innocent, as well as for the victim in the case. So we'll be making a recording on Zoom of these proceedings for my benefit, but
So we have enough time to conduct out rooms.
0 days on our case. All of it is over at Butler.
I guess maybe he doesn't look into,
have mine or something. Mr. House, we need to get going if we need to have a hearing.
We're ready to proceed, Judge. There is one matter I want to take up before we start evidence in the case.
All right.
I've talked with my client, Mr. Bishop. He would request that the case be continued until the new Butler County cases have been resolved, because these are just allegations and they hadn't had a chance to come to trial yet on them.
Well, there's other things besides the new charges. Ms. Gillette, are you aware that if we don't have a conviction, that we need some officers and some preponderance of the evidence finding, or are you wanting to just proceed on the other matters, or what is your intention here?
There's also a requirement that he report law enforcement contact to his ISO, which he was not doing. And that's notated in the warrant that he was not informing her when he was having all of this law enforcement contact. Also, he absconded, got kicked out of treatment, unsuccessfully discharged.
I'm just asking you if you want to proceed to hearing today.
Yeah, I think
without the convictions, or do you have officers lined up to testify with regard to the court making a preponderance finding? I don't need a beyond a reasonable doubt on these charges, just a preponderance.
Right. I believe we have enough other issues with him that we're able to proceed.
All right, you may call your first witness.
Your Honor, we'll call Teresa Stanfield.
Ms. Stanfield, if you'd raise your right hand, you do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you. You may proceed, Ms. Gillette.
And Miss Stanfield, are you the supervisor? Could you first please state your name for the record?
Yes, Teresa Stanfield.
And how are you employed?
By 13th Judicial District Community Corrections.
Are you the supervising officer for Mr. Bishop?
Yes, I am.
And has he had prior revocations?
Yes, he has.
And as you've been supervising him, has he had violations since you've been having him on supervision?
Yes.
I want to talk about
Ms. Norris, Monique Singleton, case numbers 2025 CR 183, 2025 CR 18. Jamal Singleton appears from the Butler County Jail's Zoom location. Joseph Favre is defense counsel. Amber Norris on behalf of the state of Kansas. These matters come before the court at this time for sentencing. Both cases came before the court on June the 17th of 2025. In the 183 case, the defendant entered a guilty plea to misdemeanor criminal damage to property, a Class B misdemeanor, sentencing set for today. The docket notes from the 18 case indicate that the defendant entered a guilty plea to.
That's how you join the room. Pass the matter. All right, Claudette G.
Hey, Kitty.
City of Detroit. Can you run her license, please?
Yes.
Versus Claudette G, case number SP 174-58991. Appearance for the record, please, Mr. Barnwell.
Good morning, Your Honor. Wendy Burnwell on behalf of the defendant.
Good morning, Ms. G. Can you state your name for the record, please?
Claudette Cecilia G.
All right, good morning to you. Today is the date and time set for a pre-trial. Ms. G, Ms. Barnwell is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Join the room. Let us know what you want to do when you come out, okay?
Okay.
All right, you don't have to join the room. Bring her back out. I'm gonna bring some other people in and name. On the iPhone, good morning to you. Can you unmute yourself and state your name, please?
Yes, good morning, Brandy Leggett.
Not you, Ms. Leggett, we already spoke.
Oh.
Morning again. Another iPhone I just let in the room. Can you unmute yourself?
Layla Lockridge.
That's Layla Lockridge. You already, all right, you fell off. Let's get you on Gray H. Gray H. Good morning to you. What is your name, please? Gray H. A lot of noise in the background, sir. You have to unmute yourself. You have to silence the noise. Gray H. You have to unmute yourself, please. Unmute yourself, sir. I'm sending you the prompt. All right, last time I'm going to ask you to unmute yourself. What is your name, sir?
My name is Eric Tobias.
Not you, Mr. Tobias.
My name is Henry Grant. I got kicked out my room. I got kicked out the room.
I know. Now, I'm not talking to you, Mr. Burns. Gray H, what is your name, sir? You're listening into the.
My name is Henry Lee Gray Jr.
Henry Lee Gray Jr. All right. Good morning to you.
My name is Henry Lee Gray Jr.
All right. Good morning to you.
Good morning.
All right, who was speaking to Eric Tabarez? Let some more people in.
I was trying to upload my document and it got kicked out.
Okay, hold on a second.
Jebby, I'm not sure if you invited me in.
I did.
Okay.
I did. Get your client out.
1 second.
Good morning, Judge Perkins.
Good morning to you. All right. BJ, is BJ there? Unmute yourself, BJ, and start your camera, please. BJ, what is your name, please?
Oh, my name is Barry Greer, sir.
Barry Greer?
Yes, sir.
All right, good morning to you, Mr.
Good morning, sir.
All right, let's go back on the record with Miss Claudette G. Miss G, I'm gonna dismiss your case. You have
Thank you.
Valid documentation. Best of luck to you, ma'am. Have a very good rest of your day.
Okay, thank you. You enjoy the rest of your day as well, Judge.
I will try. Thank you so much.
I can leave now?
You may.
Good morning, Judge.
Good morning, Ms. Barrett. Hold on a second, please. City of Detroit versus Brandy Leggett, case number SP 1749037, counts 1 and counts 2, SP 1749041. Ms. Barnwell, can you put your appearance on the record for Ms. Leggett, please?
Good morning, Your Honor. Wendy Barnwell, P42505 on behalf of Miss Leggett.
Ms. Leggett, good morning to you. Can you state your name for the record, please?
Yes, good morning. Brandy Leggett.
All right. Today is the date and time set for pre-trial. Thank you, Ms. Pre-trial. Ms. Leggett, Ms. Barnwell is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. I'm going to put you in a breakout with her. Let us know what you want to do when you come out, okay?
Your Honor, is the prosecutor available?
Yeah, it should be Alexis Snyder. I don't know if she's here yet. She's not here yet, but you may be able to text her.
Okay, can I get her information, please?
Maybe somebody else. I don't think I have her number.
See, the city attorney's office number.
Call the city attorney's office.
That-
All right. Ms. Harris, were you speaking with Tavares?
Goodness.
Yes, I was, Your Honor, but he dropped off, but now I can't get him back into the breakout room. Where is
He's
he
here.
back?
Okay, you check me.
He's here. You want him,
What's her name? You said Keith.
join the room, Mr. Tavares.
Okay. Is it mine? We have a global problem.
Gervin Barnes, you have your hand raised. What's going on? All right, let's go back on the record with Mr. Godwin. Mr. Godwin, I'm giving you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client requires a trial and the appointment of counsel.
That's what you want to do, Mr. Godwin?
Yes, sir.
I'm going to set a pretrial on September the 4th, 2025 at 8:30. That's pretrial is set so that we can make sure that you have talked to that appointed attorney. I need you to answer the calls you don't recognize. One of those calls should be that appointed attorney. Is the best number to reach 2313-423-2172?
Yes.
All right, answer the calls you don't recognize. One of those calls should be that appointed attorney. If you don't hear from that appointed attorney, then we'll appoint one for you on the date of the pretrial date on the spot, okay?
Okay.
All right, if you don't have any further questions, sir, I wish you the best of luck and have a very good rest of your day.
You too.
Excuse me, Judge Perkins.
Yes.
When you was checking everybody in, I didn't hear you call my name, and the video keep kicking me out of the court.
You know how this works, Mr. Gervin Barnes. You're checked in. Good morning to you.
Okay, I was making sure I checked in at 8:37. And I keep getting kicked out. I just want to make sure.
Let me say this to everybody. Everybody, I'm going to do the best I can to get you out as fast and efficiently as possible. I'm also do the best I can to take you in the order that you came in. And I know that everybody pretty much checked in at the same time, but the system, as soon as you check in, you'll be first, second, third, fourth, and fifth. So I know the people that are on the top of the list, they're not going to have a problem, but the people on the bottom of the list, they're going to be waiting a little while. So I'm going to do the best I can to get you out as fast and efficiently as possible, okay?
Okay, and I was just trying to make sure that I was still in because it just kicked me out like at least 7 times already.
I see. I'll keep letting you back in. All right,
okay.
Let's go, Mr. Joe Gonzalez. Are you there, Mr. Gonzalez?
Yes, I am, Your Honor.
Good morning to you.
Good morning. How you doing today?
This is the city of Detroit versus Joe Arnold Gonzalez. Case number strike that. This is the state of Michigan versus Joe Gonzalez. Case number SX414-80241. Mr. Berry, put your appearance on the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Gonzalez.
Joe Arnold Gonzalez, Jr.
All right, good morning to you. Date time set for a pre-trial. Mr. Gonzalez, I'm going to put you in the breakout room with Mr. Berry. He's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay?
Thank you.
Join the room. Let's pass the matter. Wait a minute. Mr. Berry, before you go, Mr. Gonzalez requested an appointed attorney. See who that attorney is. Miss Barrett, Attorney Barrett, good morning to you. Who's your client? All right, let's go. Let's pass the matter. Ms. Harris, are we ready on Mr. Tavares?
Ready, Your Honor. He has valid insurance.
Now let's go back on the record with Mr. Tavares. Mr. Tavares, I'm going to dismiss your case for providing valid documentation. I wish you the best of luck and have a very good rest of your day, okay?
I appreciate you, sir.
You're welcome.
I'm good to go.
You're good to go.
All right, thank you, man. Thank you, Ms. Harris.
You're welcome. Have a great day.
All right, Ms. Barrett. Mr. Berry.
Yes,
Joe Gonzalez is Ms. Barrett's client.
Okay.
So I'm gonna set you up. Let's see. Derek Lawrence. Set for trial and formal hearing. If the officer is here, we can go with it.
Good morning, Your Honor. I was wondering if I was checked in. This is John Lightfoot.
Yeah, everybody's checked in. If I haven't acknowledged you, good morning. Derek Lawrence. We have an officer, HARBIN. I haven't seen check in yet. So we'll just wait to give that officer a half-hour grace period. They keep coming in. All right, Gooseby, can you take the hat off, please, or unless it's
Sorry.
Sorry.
I'm sorry.
You're fine. Light, an imperfect perfection. Good morning to you. What is your name, please?
Garrett Goldsby.
No, I know your name. Imperfect perfection. I'm gonna send you a prompt to unmute yourself and start your video, please.
Hi, it's Brandon Granberry. I'm sorry, that's my email. I thought I put my real name in.
All right, good morning to you.
Good morning.
Layton, Wesley Layton. City of Detroit versus Wesley Layton, case number SP1664191. Appearance for the record, please.
Wesley Layton. Elwood S. Berry Jr. on behalf of the defendant, Your Honor.
All right, good morning to you, Mr. Layton. State your name for the record, please.
Good morning, Wesley Layton.
All right, Mr. Layton, today is a date and time set for a pretrial. I'm gonna put you in a breakout room with Mr. Berry. He's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Join the room, let us know what you wanna do, come out, okay?
All right, thanks.
Let's pass the matter. All right, let's go with George Green.
Good morning.
Good morning to you. You have a middle name, sir?
George, did you call George Green?
Yes.
George Rufus Green?
All right, good morning to you.
Good morning.
City of Detroit versus George Rufus Green, the third, case number SP1738020, council 1 and council 2. Appearance for the record, please.
Wendy Barnwell. Oh, sorry about that.
That's all right, Ms. Harris.
Chair Eka Harris, on behalf of the defendant, please state your name.
George Rufus Green.
All right, today is the date and time set for a pretrial. Ms. Harris, give Mr. Green an updated offer. Keep in mind, if you don't like the offer, Mr. Green, you have an absolute right to a trial,
okay?
Join the room, let's pass the matter.
We're already on Leggett.
All right, let's go back on the record with Ms. Leggett. Ms. Leggett, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Granted, she wishes to accept the offer of the prosecuting attorney. They offered her for her to plead to improper pates on the ticket ending in 0481, dismissing the tickets ending in 0371 and 0372.
You want to take the deal, Ms. Leggett?
Yes.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
Yes.
You can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $100 in fines?
Yes.
You understand that you have an absolute right to a trial?
Yes.
Ms. Barnwell went over your other advice or rights in the breakout room, did she not?
I went
Yes.
over her constitutional rights, Judge, yes.
You understood those rights?
Yes.
Do you have any questions about those rights?
No.
You know by taking the deal, you're gonna give those rights up?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No.
Let me draw your attention back to June 27, 2025, around 3:40 p.m. in the city of Detroit, in the area of McNichols and McGraw. Did you have an occasion on that day to come in contact with the Detroit Police Department?
You said June 27th?
Yes.
Of what year?
This year.
Was that the date that I got my ticket?
That's what they say.
It said McNichols?
Was it? No, Livernois and McGraw.
Oh, yes.
All right. Did you have any, you are operating a motor vehicle?
Yes. I was parked by the time they pulled over. I just my keys was out, but I was still in the car. But yeah.
But you had pulled over because you tried.
No, I was at my destination.
Oh, okay. All right, but you were driving and this motor vehicle, right?
Yes.
Is that your car?
Yes.
And did you the car was operable, right?
Yes.
And did the officer ask you to produce valid insurance?
Yes.
And you couldn't do so, could you?
No.
And why is that?
I haven't. My plates were expired and I didn't renew them at the time.
Because we're talking about your insurance. Because what? Huh? Why didn't you produce the insurance?
I didn't have insurance at the time.
Very well. I'm gonna find you guilty of the amended count of improper plates with stipulated proper cause. I'll dismiss the other two matters.
So stipulated, Judge.
All right, I'll dismiss upon payment of $240. When can you pay it, Ms. Leggett?
You said 240. I could pay it within 2 weeks.
All right, pay it by the September, not the 5th. Come back on the 5th. If you pay it at any DivDat kiosk in the city of Detroit, I'm told you can upload the DivDat app to your phone or come on down to the courthouse and pay it. If you pay it one of those two ways, it'll go through instantly and you do not have to come back, but that's gonna be on you to make sure that it's been paid. I'll dismiss the case, but if you wanna see it through, you're more than welcome to come back at 8:30 in the morning, okay?
Okay, thank you.
Best of luck to you, ma'am. Have a very good rest of your day.
You too.
We have Detroit, Ms. Barnwell versus Jamar Luster, case number SP168970, count 1. Count 2 is in the fall. I'll put count 2 on there as well. Appearance for the record, please.
Yes, I'm here.
Good morning, Your Honor. Wendy Barnwell on behalf of the defendant, Mr. Luster.
Mr. Luster, good morning to you. State your name for the record, please.
Good morning, Jamar Luster.
All right, today is the date and time set for arraignment on the bench form for purposes of arraignment. Counselor?
Your Honor, we would respectfully ask that this court set aside the bench warrant. Enter a plea of not guilty.
We'll enter a plea of not guilty on your behalf, give you a $0 bond. Mr. Luster, I'm gonna put you in a breakout room with Ms. Barnwell. She's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay?
Okay.
Good morning to you, Mr. Graves. Join the room, let's pass the matter. Yes, sir. Is Miss Javaris Reed.
Yes, sir.
Good morning. Are you Officer Reed?
Yes, sir. Sergeant Reed, sir.
All right, Sergeant Reed, good morning to you. And do this. All right, this is the city of Detroit versus Sarah Bassem Burrell, case number SP 174 3470, counts 1 and counts 2. Appearance for the record, please.
Good morning, Judge. Is this mine? Sarah Goriel?
Goriel, yes. I'm sorry.
Yeah, Clay Miller, PA 6291, standing in for Attorney Ryan Hill here on behalf of Ms. Goriel. Your Honor, I still need to speak with the prosecutor. She's busy though. Could I chat with Officer Tyson in a breakout room? He gave me the okay to talk to him.
Officer Tyson, are you there?
Yes, Your Honor, I'm still here.
Let me put you in a breakout room with the counselor. Unless you feel more comfortable going to the city attorney.
I can talk to the defense.
Okay, very good. All right.
Thank you.
Join the room, please.
Attorney Taylor has Winifred Green.
Winifred Green. Where's Mr. Green?
It's a diploma here, Your Honor.
All right. City of Detroit. Come on, Mr. City of Detroit versus Winifred Little Green. Case number SP 1757031, counts 1, counts 2. Here for the record, please.
Good morning, Your Honor. Episode 357, 166, appearing on behalf of Ms. Green. And I have to make decisions in this matter, Your Honor.
All right. I'll waive your client's presence. You indicated to the court that you have authority to enter into agreement on Ms. Green's behalf. Is there an Officer Henderson? Is Officer Henderson is here?
He's here. Okay, Your Honor, I gave proof that she had insurance, so we're gonna check this deal. 150.
Is it blockade?
Yes.
Officer Henderson, are you there?
Good morning.
Good morning. State your name for the record, department and badge number, please.
Officer Henderson, badge 2212, Detroit Police Department.
All right. Mr. Taylor has provided, as an officer of the court, I'm going to accept his representation, that he's provided valid insurance, and I guess he got the offer of blocking traffic. All right. For the speeding ticket, okay?
Sounds good.
All right. Stipulate to the face of the ticket as an act of factual basis for that responsible plea on your client's behalf.
I do, Your Honor.
Stipulate the probable cause for the dismissal of the other matter.
Yes, sir.
All right. With that, I'm going to find your client responsible for the amended count of blocking traffic. And dismiss the other matter. Pay by 9/4/2025. All right. If there's nothing further, Officer Henderson, if you don't have anything further, I wish you the best of luck and be safe out there. And good to see you, Attorney Taylor. Best of luck to you. Have a very good rest of your day.
Yeah, good. The amount of this fine.
170.
175. Thank you, Your Honor. Have a good day.
What's Attorney Taylor's first name? I didn't quite get that.
Edward Taylor. And what's your P number?
57166.
Thank you.
All right, very well.
Thank you.
Is Ms. Barrett ready? Joe Gonzalez is waiting on you. Mr. Hajazi, good morning to you.
Good morning, Your Honor.
Who's your client?
I have Ali Olabi, and we were going to check if a trooper checked in. Williams Weston.
Trooper Lester.
Weston.
I've had a trooper in here that checked in. Trooper, are you there?
Yeah, I'm sure we can snatch up and make it fast, right?
City of Detroit versus Ali. Strike that. This is the state of Michigan versus Ali Olabi. Case number SX45694301. Appearance for the record, please.
Rami Hijazi, P82830 on behalf of Ali Olabi. Your Honor, would be requesting a waiver of his presence. This is a civil infraction. I do have authority to move forward.
All right, I'm going to waive your client's presence. Is there a trooper, Weston Williams, badge number 283, a trooper Weston Williams? Hearing no response.
Your Honor, I would have a motion.
Go ahead, Counsel.
Yes, Your Honor. Given the time is now currently 9:21, this matter was scheduled for an 8:30 a.m. formal hearing. You have shouted out for Trooper Williams Weston. We haven't heard a response. I would ask that Your Honor dismiss this matter.
All right. Case is going to be dismissed. If there's nothing further, have a very good day and best of luck to you.
Thank you, Your Honor. It was always a pleasure to see you. Bye-bye.
All right, thank you. City of Detroit versus Jacque Ramona Good. Is Jacque Good here?
I am here.
Good morning to you, ma'am. There's case number SP 1727871. Ms. Good, good morning. State your name for the record, please.
Jacque Ramona Good.
Jacque, I'm sorry. There's date and time set for a trial. This is Ogletree case. Ogletree, are you there? The officer did appear. That was Officer Scutton. He indicated to the court that he had no recollection. I'm going to dismiss the case. No recollection. Is Attorney Ogletree here?
He may be in a breakout room, Your Honor.
All right. I think he was the only person that he had today as well. So he may have stepped out. Oh, he is in the breakout. Let's see. Attorney Ogletree, can you put your appearance on the record for Jacque Good?
Aaron Ogletree on behalf of Ms. Good, P number 69167.
All right, case dismissed, no recollection. If it's nothing further, best of luck to you. Have a very good rest of your day.
Thank you. You too.
All right. Let's go with let's go back on the record with George Green. Mr. Green, I'm giving you an opportunity to speak to counsel. Counsel, your client wants a trial date?
That is correct, Your Honor.
Mr. Green, the trial date is going to be on September 11, 2025 at 9 a.m. If there's nothing further, Mr. Green, have a very good day. Best of luck to you.
Okay, appreciate it. Thank you.
Shirley Lee.
Shirley G. This is the City of Detroit, Ms. Harris versus Shirley Lee, case number SP 1728358, counts 1, 2, and 3. Appearance for the record, please.
Sheriff Harris, on behalf of Ms. Lee, please state your name for the record.
We have somebody here that speaks French.
Speaks French?
Yes.
Parle français?
Were you able to get his name?
Yes, his name is
Shirley
Ms.
Lee.
Can you state your name for the record?
Where's Lee? Shirley Lee. She was here.
She's there. I sent her the prompt to.
Yes, my name is Shirley Lee.
All right, good morning to you, Ms. Lee. Day is date and time set for a pre-trial, Ms. Lee. Ms. Harris is gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Join the room, let us know what you wanna do when you come out, okay?
And you said, SP 17.
Ms. Lee, join the breakout room. What's going on?
Your Honor, I'm ready on Luster. Thank you.
Let's go back on the record with Mr. Luster. Mr. Luster, is my understanding you want a trial date as well?
Yes, sir.
Our trial date is going to be on September 11th, 2025 at 9 a.m. If there's nothing further, you have a very good day. Best of luck to you.
Thank you.
All right, Ledbetter, Kimberly Ledbetter.
Yes.
Good morning to you, ma'am. This is the city of Detroit versus Kimberly Ledbetter, case number SP 1680140, counts 1 and counts 2. SP 168. What's going on here? No, with this Granberry. Got some kind of control. SP 1681, that's right there, SP 168014111. Appearance for the record, please.
Good morning, Your Honor. Wendy Barnwell on behalf of Ms. Ledbetter.
Ms. Ledbetter, can you remember the business, please? Can you state your name for the record, please?
Yes. Kimberly Ledbetter.
All right, good morning to you, ma'am. I need to turn your camera on.
Okay. Okay. I'm using my back camera, so it's a little unsteady.
Very well. All right, you're good. All right, day is the date and time set for a pre-trial. Ms. Ledbetter, I'm gonna put you in a breakout room with Ms. Barnwell. She's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Ms. Barnwell, Ms. Ledbetter has a valid driver's license.
Okay.
Are you asking me?
No, I'm telling you.
Okay.
All right, if there's nothing further, Ms., I'm gonna put you in a breakout room. Let us know what you want to do when you come out, all right?
Okay. Thank you.
Cool. All right, join the room, please. Let's pass the matter. Mr. Berry, let's go back on the record with Mr. Layton. Mr. Layton, I'm giving you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, we seek a trial date and the appointment of counsel.
That's what you want to do, Mr. Layton?
Yes.
I'm gonna set you with a pre-trial date first. That date is set to make sure that you hear from that appointed attorney. If you don't hear from that appointed attorney on the next court date of September 4th, we'll get one appointed to you on the spot. Is 567-420-9191 a good phone number for you?
Yes.
All right, answer the calls you don't recognize. One of those calls should be that appointed attorney. And again, if you don't hear from that appointed attorney on the 4th, then we will get one appointed to you on the spot, okay?
Okay.
All right, have a good day, sir. Best of luck to you.
You too, thanks.
John Lightfoot.
Good morning, Your Honor.
Morning. This is the city of Detroit versus John Lightfoot. Case number SP 174-1581, counts 1, 2, and 3. SP 175-9960, counts 1 and counts 2. SP 175-9977, counts 1, 2, and 3. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant, Your Honor.
All right. Mr. Lightfoot, you stated your name for the record. Cool. I'm gonna put you in a breakout room with Mr. Berry. He's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay?
Thank you, Your Honor.
All All right, you're welcome. Join the room. Let's pass the matter. All right, let's go back on the record. Mr. Miller, are you ready on your client?
Your Honor. Yes, Judge, we're ready. One second.
Let's go back on the record with Ms. Burrell.
Do I supposed to stay in here still?
No, if you got your date, sir, you're fine.
Thank you.
Have a good day.
You too.
Did you work something out with Officer Tyson?
Prosecutor Schneider now on the failure signal to amended charge of impeding, and count one would be dismissed.
All right. You want to stipulate to the base of the ticket as an active factual basis?
Yes. So stipulate, Judge. And I have authority to act on behalf of my client. Sorry.
Stipulate the probable cause for the dismissal of the other matter.
So stipulate.
All right, I'm going to find your client responsible for the amended count of blocking traffic. And $175. I'll dismiss the other count. $175. Pay it by 9/4/2025. There's nothing further. Officer Tyson, you be safe out there. Have a very good rest of your day. And Mr. Miller, you be safe and have a good day as well.
Thank you, Your Honor. Have a good day.
Thank you, Judge. Thank you, Officer Tyson. Take care.
All right, Miss Barrett, are you there? Attorney Soroki, good morning to you.
Good morning, Judge. I'm here on Kenneth Owens. I don't see him in the courtroom. I don't see the officer or the
officer
animal control officer here.
The officer is here to complain.
Okay.
Is Kenneth Owens here? Kenneth Owens. I thought I checked Kenneth Owens in. Thomas.
Okay.
All right, City of Detroit. Good morning to you versus Thomas Owens. Case number B144245525, B144246225, B144242825, B144242925, B144322625, B144322725.
Oh, okay.
Who's making the noise? Appearance for the record, please, Mr. Soroki.
Alan Soroki, P37441, appearing on behalf of the defendant, Kenneth Owens.
All right, Mr. Owens, how would you like me to address you, sir?
Kenneth Thomas Owens.
All right, good. Mr. Kenneth Thomas Owens, state your name for the record, please.
Kenneth Thomas Owens.
All right, good morning. Mr. Jeff Brooks, state your name for the record, please.
Jeffrey Brooks.
And Officer Investigator, is that Investigator Charleston?
Yes, Investigator Charleston.
Good morning to you. State your name, badge number, and department for the record, please.
Investigator Charleston with Detroit Animal Control, badge number 11.
All right, here's how we'll do it. I'm gonna, and Miss, is Attorney Schneider there?
Good morning, Your Honor. Alexa Schneider for the people, P80322.
All right, good morning to you. I'm gonna put Mr. Kenneth Thomas Owens in breakout room 7, Mr. Soroki. Ms. Schneider, speak to, and you'll have control over Mr. Jeffrey Brooks and the officer. You can put them in any breakout rooms you want. Let's see if we can work this out. Today is the date and time set for a trial, okay?
Thank you, Your Honor.
Thank you. Mr. Owens, go to breakout room 7 and wait on Mr. Soroki, okay?
Yes, Your Honor.
Excuse me, Your Honor. This Corporal Whitehead, can you put me in the breakout room with the the prosecutor? I got a funeral detail I'm doing today.
Yeah. Good morning, Corporal Whitehead.
Good morning, sir.
All right, we got Derek Lawrence we can start on now. Is Derek Lawrence still here? Yeah, all right, give me a second, Mr. Lawrence. All right, I'm gonna have to go downstairs too. Where's Miss Barrett? Miss Barrett. I'm waiting on an attorney now. Any other counselors ready?
Judge, I don't know if I'm supposed to go into any room to talk with anybody for Gilan, G-E-L-A-N.
All right.
Your Honor, I'm ready on. Sorry, Judge.
Sorry, City of Detroit versus Talal Kassim Mohammed Galan, case number SP 1766139, counts 1 and counts 2. Appearance for the record, please.
Good morning, Judge Danny Batty on behalf of Mr. Gilan. Asking the court to waive his appearance for today.
And you've got authority to enter any agreement on your client's behalf?
I do, Your Honor.
All right, I'll waive the presence. Is Officer Bishop here? Officer Bishop. Hearing no response, let's see. And not having seen that officer on my list.
Good morning, Your Honor. It's Corporal Whitehead again. If you don't mind, I got a funeral detail. I talked to the prosecutor. I'm gonna have to take off if you don't mind, sir.
I don't mind. Go ahead.
Okay,
All right,
thank you, sir.
you
Okay, thank you.
All right, go ahead with your motion, Counselor.
Judge, at this time, we'd respectfully ask for a dismissal.
All right, I don't hear an Officer Bishop. There's no officers every officer's here. I don't see the officer on my list. Officer, grant the motion to dismiss. Something further, Counselor. Have a very good day. Best of luck to you.
Thank you, Judge. Take care.
Counselor Borman, good morning to you. You want to go into the breakout room? Who's your client?
Kellen Leak, Your Honor.
All right, Kellen Leak is here. Let's call. City of Detroit versus Kellen Michael Leak, case number SP 1746759, counts 1, 2, and 3. SP 1746716, counts 1, 2, and 3. Appearance for the record, please.
Good morning, Your Honor. Will Broman on behalf of Mr. Kellen Leak, P85364. Mr. Leak is appearing via Zoom. Mr. Leak, would you please state your name for the record?
Good morning. My name is Kellen Michael Leak.
All right, good morning to you, sir. Today is the date and time set for a pre-trial. Do you want to speak with the city attorney about it? Or do you want to just go straight to trial?
Yes, Your Honor. Your Honor, I would like to speak to the city attorney on it, and I will note that I have not received any discovery.
Okay, very good. I'm going to put you in a breakout room with Ms. Snyder, or I'm going to put your client in breakout room 8, Mr. Lee. If there's some sort of resolution, make sure your client has, if it's a plea, guilty plea, make sure your client fully understands his advice or rights, all right? Join the breakout room 8, wait on the attorney to come see you, okay, Mr. Lee?
Thank you, Your Honor.
Who had, all right. Okay, let's go back on the record for Ms. Shirley Lee. Ms. Lee, I'm giving you an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor, I'm awaiting a response from the city attorney.
Okay.
If we could just pass this matter briefly.
Very well. Gales, Lawrence Gales. Where's Mr. Gales on the telephone? Can you press *6 to unmute yourself, Mr. Gales? *6. Mr. Lawrence Gales, press *6 to unmute yourself, please.
Gales.
You there? Okay, this is the city of Detroit versus Lawrence Edward Gales. Case number SP 176-1285, counts 1, 2, and 3. It has an SP 176-1291. It's missing a number. I guess that's count 1, and SP 176-12912. Appearance for the record, please, Ms. Harris.
Sherika Harris, on behalf of Mr. Gales, please state your name.
Lawrence Gales.
All right, good morning to you, sir. Today is the day. Okay, perfect. Go ahead, Counsel.
For the purpose of arraignment, my client stands mute.
Well, enter a not guilty plea on your client's behalf. We'll give your client a $0 bond. Mr. Gales, I'm gonna put you in a breakout room with Mrs. Harris. She's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. He's in there, Miss Harris. That's the matter. Let's go back on the record with Mr. Lightfoot. Mr. Lightfoot, I'm giving you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client would avail himself of the people's current offer, which is to have him enter a plea to 1 count of failure to display and 2 counts of improper plates.
You want to take the deal, Mr. Lightfoot?
Yes, Your Honor.
Can you raise your right hand, please? Okay. Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
Yes, Your Honor.
That's what I'm with the judge.
All right, you can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes, Your Honor.
You understand that you have an absolute right to a trial?
Yes, Your Honor.
Mr. Berry went over your other advice or rights in the breakout room, did he not?
Yes, he did, Your Honor.
You understood those rights?
Yes, Your Honor.
You have any questions about those rights?
No, Your Honor.
You know, by taking the deal, you're gonna give those rights up?
Yes, Your Honor.
Has anybody offered you anything other than what's been stated in the record?
No, Your Honor.
All right, is this your 2004 Ford?
Yes, it was, Your Honor.
Now, let me draw your attention back to July the 19th, 2025, around 8:29 a.m. in the city of Detroit, the area of Warren in Archdale. Did you have an occasion on that day to come in encounter with the Detroit Police Department?
Yes, Your Honor.
You were operating a motor vehicle?
Yes, Your Honor.
The officer asked you to produce a valid driver's license.
Yes, he did, Your Honor.
And you couldn't do so, could you?
No, Your Honor.
Why is that?
I'm sorry?
Why couldn't you produce the license?
Because I had lost my license some time ago. And so.
Because you didn't have a license, right, Mr. Lightfoot?
No, I had no license, Your Honor.
Very well. Find your client guilty of the amended count of failure to display. Mr. Lightfoot, did he also ask you to produce valid insurance?
Yes, he did, Your Honor.
You couldn't do that either, could you?
No, Your Honor, I could not.
And why is that?
Well, because license.
Short story.
Okay, because my license was revoked, I'm unable to insure or register a vehicle in my name.
That's too long of a story because you didn't have insurance, correct?
Yes, Your Honor, sorry.
Very well. Find your client guilty of the amended count of improper plate. And then what was wrong with the, go ahead, Mr. Berry.
I'm sorry, Your Honor. I thought you said, it's just that he's going to seek community service. I just wanted to get that.
What was wrong with the plate on the vehicle, sir?
It was an improper plate.
And how was it improper?
It was a paper plate, Your Honor.
And it wasn't valid, right?
Yes, sir.
All right, very well. Find your client guilty of the amended, as charged, the improper plate. All right, so 24 hours of community service will clear it up. I'm only gonna fine you for the 2. I won't fine you for the 3rd one. 24 hours of community service. I need a good phone number from you.
Good.
It's 313 258 0697.
And I'm gonna give you the number to the community service coordinator. And that's just so that you have it. They should call you. You shouldn't have to call them. But if it gets around and you see that later on in the week or next week, they haven't contacted you, you need to reach out to the court or reach out to them. That number is 313-965-8130. I'm gonna give you until, 313-965-8530.
Did you get that? Okay, I got it, sir. Thank you.
I'm gonna give you until September the 19th, complete those community service hours. If you don't have any further questions, sir, I wish you the best of luck. Have a very good rest of your day, okay?
I do have one last question, Your Honor. I'm sorry. I was trying to wake up my son to get that phone number, but you said they were going to call me within a week or something?
Well, they should call you if a week goes by and you haven't heard from them, then you need to reach out to them or reach out to the court, okay?
Okay.
All right. If there's nothing further, sir, I wish you the best of luck. Have a very good rest of your day.
Thank you, Your Honor. I hope you have a good day too.
You have a good one. All right, Mr. Berry, this is the city of Detroit versus Derek Dwayne Lawrence. And those would be case numbers SP1712168, counts 1, 2, and 3. SP171217001. That would be 207170331. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Lawrence.
Derek Dwayne Lawrence.
All right. Today is the date and time set for a trial. Is there Officer Del Zotio? Give me the correct pronunciation. Sorry.
Officer Del Zacchio, good morning. Badge 706.
Sorry, Officer Del Zacchio. All right. And that's Detroit Police Department?
Yes, sir.
And then is there an officer? Harbin, Officer Harbin. All right, I don't hear the Officer Harbin has not responded, and I don't see Officer Harbin on my list. So,
motion is for dismissal, Your Honor.
I'll grant that motion to dismiss. No officer. Mr. Berry, give Mr. Lawrence an updated offer. Keep in mind, Mr. Lawrence, if you don't like the offer, today is the date and time set for a trial, okay?
I gotta beat that.
When you're wrong, let us know what you want to do when you come out. All right, let's go back on the record with Ms. Ledbetter. Ms. Ledbetter, I'll give you an opportunity to speak to counsel. Counsel, what's your client? Your client is a dismissal for compliance.
Yes, Judge. Wendy Barnwell on behalf of Ms. Ledbetter.
Ms. Ledbetter. How do we know? Okay, yeah, well, we'll dismiss the case, Ms. Ledbetter, for providing valid documentation, all right?
Okay. Now, Judge, there's one other matter. The prosecutor did offer to dismiss the 2 civil infractions, but she indicates that they were defaulted. I suspect they're defaulted. I'd ask that they be respectfully set aside the default so they can be properly dismissed.
All right, I'll set aside the default cases dismissed. Best of luck to you, Ms. Ledbetter.
Thank you. I appreciate you so much. Have a good rest of your day.
You have a better one. This is the city of Detroit versus Kip Ramon Gordon, case number SP 175-3375, counts 1 and counts 2. Appearance for the record, please. Ms. Barnwell.
Wendy Barnwell on behalf of Mr. Gordon.
Mr. Gordon, are you there?
Yes.
State your name for the record, please.
Kip Gordon.
All right, good morning to you. Day is date and time set for a pre-trial. Mr. Gordon, Ms. Barnwell is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. I'm going to put you in a breakout room with, or let us know what you want to do when you come out, okay?
Okay.
All right, pass the matter. Officer Reed.
Yes, sir. Yes, sir.
Good morning to you.
How are you?
I'm well.
I am. Can I get a breakout room with the prosecutor? We have to go to a funeral.
iPhone 6, good morning to you. What is your name, sir? You just muted yourself. Unmute yourself, please.
Hello, Octavian Lozier.
Lozier, good morning to you.
Hello, good morning.
Excuse me, Judge.
Yeah, your client is in breakout room.
He was supposed to come out. We need a pretrial date so I can get discovery.
Excuse me, Judge.
City of Detroit versus Joe Arnold Gonzalez Jr., case number, strike that, State of Michigan versus Joe Arnold Gonzalez Jr., case number SX 414-80241. Appearance for the record, please.
Well, good morning, Judge. Melita Baird on behalf of Joe Gonzalez. Judge, I received this matter. I need to get the discovery for him, so I'm requesting a pretrial.
Anything from the state?
No, Your Honor.
Mr. Sebring, is there anything you'd like to add?
I read out a statement if you'd like to hear that.
Sure.
All right. Good afternoon, Your Honor. Thank you for giving me an opportunity to hear me out today and a chance to move on from this chapter of my life. I understand that what I did was wrong and there's no excuse for my actions. I believe the person I was when I was 18 does not reflect the person that I am today. I've stayed clear of any legal troubles since then. I now have 2 wonderful children that I would like to give the best life possible, and I believe this may hold me back from doing so. I successfully completed my community control along with all of the requirements that came with it, such as completing the Thinking for a Change class, keeping a full-time job, and getting my high school diploma. Although it has been difficult, I have maintained employment since then, although many jobs have denied me due to my record. I worry that I may have issues finding a place to live due to my record, as well as being able to find a good career. I just want to be able to give my children the best life possible without my past coming back and preventing that. With all things considered, I believe that sealing my record will let me in that chapter of my life and move forward to a brighter future ahead for not only myself, but my children as well. Thank you.
Thank you, sir. The court will find that the required period of time has passed since your final discharge from supervision. There are no criminal proceedings currently pending against you. the offenses for which you were convicted are eligible to be sealed, and your interest in having these records sealed is not outweighed by any legitimate government need to maintain the record. So I'm going to grant your request, sir. If you'll give me about a few more seconds, I'm going to file this electronically right now. And we're done. Mr. Laux is going to hand you a copy of this document for your records. So if there's ever an issue in moving forward, you'll have some copy that I ordered this record sealed.
All right. Thank you, Your Honor.
Good luck to you, sir.
Thank you.
Damon Oliver. Mr. Schwander.
Thank you.
All right, these are case numbers 19CR36010 and 19CR35481, the state of Ohio versus Timothy Schwander. Mr. Schwander is before the court on his application on both cases to seal his record of conviction. Has everyone had an opportunity to review the report of probation?
Yes, sure.
Anything from the state?
These are not eligible offenses. He's convicted of violation of a temporary protection order that is not eligible to be sealed under current Ohio law.
Mr. Schwander, do you understand what she's saying?
Yeah, I heard what you said. I have kids too, and I'm trying to move ahead in my life, and I want to be an EMS firefighter, and I can't do that because of my record. And like last 6 years, I haven't gotten in any trouble because I stopped hanging around with bad people. And I know the courts might see it differently, but it was a big misunderstanding what happened last time I seen you.
Let me interject, Mr. Schwander. This really isn't something where you're going to be able to talk me into or out of something, because as the prosecutor has pointed out, one of the findings that I have to make is that the offense of which you were convicted has to be an eligible offense. So there are still certain offenses in the state of Ohio that cannot be sealed, that cannot be expunged. And unfortunately, the prosecutor is saying, and I agree with the prosecutor, that this is one of these are those offenses. Okay. And there's a reason for that, but I don't have discretion to say you have a good reason to do it, because if I grant you an sealing, they're going to appeal it. And the 12th District Court of Appeals is going to reverse me and say, yeah, he's not eligible for an expungement on these offenses. So it has nothing to do with the reasons you want it expunged or sealed. Has no reasons for how well you've done since you were off community control, because obviously you have been doing well. It's just that I don't have the discretion to grant it in these cases. Now, what I will do is I'll give you an opportunity if you want to talk to an attorney to see if an attorney can bring a different perspective to this. But at this point in time, I don't see where I have the authority to grant you your request. Does that make sense? I just don't have the discretion to do that. There are just certain offenses.
But wasn't it non-violent domestic violence?
They're violation of protection orders. Felony, that one is.
I just thought there were two different charges of domestic violence. Either it's
No,
aggressive or violent.
you were charged with violation of protection order.
He does have convictions for domestic violence as well, which are also not eligible to be sealed.
Well,
but not in
again,
this case.
the way they do it now is they used to look at it from if you had an F1 on your record, for example. And then you got this petty theft or this felony theft charge. They used to say, well, you're not eligible because you had this other charge. But nowadays they've changed it and they look at not your entire record, but the individual offense and whether it qualifies for sealing or expungement. So they're constantly changing it, broadening it. But what I'll do is I can reset this in 30 days and give you an opportunity to talk to an attorney to see if they can make some different argument. But at this point in time, again, the offenses themselves are not eligible to be sealed. You're not charged with. In this case, it looks like it's a.
Breaks my heart. Oh man. I feel like my life's over, 35 years old. I've got 3 kids.
Yeah, it looks like on the first case, it looks like you were convicted of a misdemeanor violation of protection order. And then the second one, it looks like it's a felony violation of a protection order. Is that right?
May I ask you a question, sir?
Yes, sir.
So I know the laws changed over and over and over. But it used to be that if, like, my ex-wife filed this protection order and if she violated it, then it gets annulled or she gets in trouble. But then at the time when she was violating it, she didn't. I tried to tell everybody. She didn't get in trouble at all.
That's correct, because if she's the protected person under a protection order, the order is against you in favor of her. She can violate the order without any consequence. It's you that always suffers consequence.
Right.
The person that the protected party can violate the order. I mean, that may be a factor for the court to consider, but ultimately the order is again. I tell people that when I issue no contact orders or protection orders, that even if she calls you, you got to hang up. And I did that as a private attorney as well. So, yeah, if you want 30 days before I rule on this, or do you want to talk? So give you a chance to talk to an attorney. I can do that.
I don't have any money for an attorney, but
some attorneys may give you a consultation for just to look at it and say, yeah, the judges, you're not going to win this argument.
I don't know. I'm struggling. I mean, I'm really trying to move on in life and be a firefighter. I got Supreme Court.
I will just throw this out there. And again, you probably need to talk to an attorney because you have.
All of it's from Mason. I grew up over there, and they pretty much harassed me after a couple of times of getting in trouble. I mean, I just hung around bad guys, and I stopped hanging around with them. And that's why I haven't been in trouble in 6 years.
I mean, it looks like you have an felony arson on your.
Yeah, I was 19 years old.
I mean, that would probably prevent you from being.
It was an abandoned barn. I was underage drinking. The Indians were selling me alcohol. They should have got in trouble for that. But
there is a procedure. It's called a certificate of qualified exemption. That is something that you could possibly look into, that despite your record and your preliminarily being ineligible for becoming a firefighter, that you could at least get a judge's order
really?
Yes.
Well, I probably need to do that.
Yeah, but I'm not in a position to give you legal advice, so you need to talk to an attorney, because again, whether even the court would grant that is a whole nother issue. But I'm not able to, or I don't have the discretion to grant your request today. Okay. It's called a certificate of qualified employment exemption. I thought the E was for exemption.
So
certificate of qualified employment?
I think it's certificate of qualified employment.
Okay, it's CQE, I know that.
Yeah.
Okay.
Well, if it means anything, like I said, I've been self-employed since high school, and I have hundreds of references, people I've done work for, and primarily most of them would not say I'm an aggressive, violent person. If that means anything.
Yeah, that's not before me today. So again, I'm just telling you that you're not eligible for a sealing. Okay. All right, sir. Sorry about that. Thank you.
Yep.
Okay, this is case number 24CR42173, the state of Ohio versus Shanice Burgess. Ms. Burgess is before the court on a review hearing. All right, Ms. Burgess, what's going on?
So when I left here, when I was reporting to the lady Hallie, the report lady here, I told her that I had a scholarship with MedVet, which I have a letter from MedVet. I gave her a copy of this, and my scholarship allowed me to go from Georgia to Kentucky 2 days a week to work there, you know, as an intern until I got the scholarship, and then I could leave and go back home to Georgia. I gave the lady, the other lady, when the day I was sentenced with you, and I had to go back over there to talk to the lady, I gave her the address to Georgia. I told her the same situation I had been telling my PO that I had been reporting to here monthly. And she said that she had to send it to Kentucky because that's the information that she initially had on file. I was like, okay. So when it got to Kentucky, I went to the PO office there in Kentucky, and I explained to him that I'm only there 2 days a week, that my primary address is in the state of Georgia. He asked me for my license, registration, everything's Georgia. He said, I'm going to send this back because your scholarship's up, ain't it? And I said, yes, sir. He said, well, I'm going to send this back to here, to Ohio. He said, so you'll be reporting in Georgia. So I talked to the lady. I can't remember her name. It was the lady over here, the supervisor. I talked to her. She told me that she was going to redo the work and send it to Georgia. And since then, I've been in contact with Officer Thomas in Georgia, and I've reported to her every month. She told me that she sent a letter back to the probation office here to be signed because something wasn't signed correctly. And since then, I talked to her again yesterday. She rephrased it. I'm waiting on that letter to be signed. However, Shanice, just do what you got to do. And when you come back here, come into my office to see me. And I'll just go on and just report it as you're coming in to report to me. But she said she sent something back to be signed months ago, over 3 months ago. She told me to let you know, to give you her telephone number as well. And she's the supervisor over that probation office. And since then, I have completed my restitution, and I'm in a mental health program as was instructed on my paperwork as well. I've called every month here and left several messages with the lady to try to see what was going on. I think I did talk to a lady named Molly the other day, and she was advising me just to come here and do what I needed to do for us, whatever for you.
When did you make your payment?
So I haven't made the payment yet. I didn't make a payment. On this paper that they gave me, it didn't give me an instruction of the payment or where I needed to make the payment to. And I still have the form right here. So I didn't do that as of yet.
I thought you just told me you'd paid restitution.
No, I didn't say I paid the restitution. I reported to her, and I did this community service stuff that you advised me to do. I haven't made a payment on my probation fee because I technically haven't had a probation
Ms.
officer.
Burgess, let me stop you. When I'm talking about payment, I'm talking about the restitution.
No, sir. No, sir. I have not made a payment on my restitution, sir.
Why not?
I was a little confused about all of this stuff, as I said before. I'm not even sure who I have to make the payment to. Do I make it to Georgia? Did I make it to Kentucky? I was so confused about all of that stuff. And then I looked on here and it didn't give me any description of where to make the payment to. I can give you this form. So I knew that you had told me in open court that I needed to make the restitution or whatever, because I would have to be responsible to pay it because you didn't have my co-defendant either. And so I did want to talk about that too today.
I didn't have your co-defendant. What?
He wasn't in custody. He was on the run or whatever at that time or whatever. So it was you said somebody has to pay it. It's only fair because somebody got to pay these people.
Yep.
And I agree. Totally. I agree.
Well, the way this works, Ms. Burgess, is that, people oftentimes think that when, in this case, it's $4,000 some owed in restitution to the victim of the case. And when there's two people involved, people oftentimes think that they're only responsible for half of it. But that's not what the court ordered. I ordered you to pay restitution of $4,114 to the victim in the case, and it's joint and several. Now, what that means is that the money, the $4,000, can be collected from both of you or each of you.
Okay.
So you are responsible for 100% of $4,114. Now, if Mr. Ross, when we find him and get him and order him to pay whatever he pays, because he'll have the same order.
Gotcha.
So if he pays the same amount, you both pay your $4,000, you'll get half of it back. But
I didn't know that part.
Yeah, joint and several means you're responsible for all of it jointly and individually.
Gotcha.
That's what it means. Okay. So I don't care about. I shouldn't say I don't care. I've worked with these officers, these probation officers, long enough to know that the confusion isn't on their end, it's on your end. Now, maybe you had too many things going on and weren't comprehending what it was they were explaining to you. So at this point in time, you have a fixed address in the state of Georgia, correct?
Yes, sir.
We're going to get her to sign this ICOTS transfer today, correct?
Yes,
We're going to make sure you're going to go back to probation today, and you're going to make sure that they have your correct address, correct email address, correct phone number. So, and then it's your responsibility from today forward to make sure that if there are any changes to any of that information, that you provide that information to the probation officer in writing. Are we clear on that?
We're clear on that.
Okay. And it is your responsibility to make, and I'm going to have, is Officer Rose here today?
She is not, either myself or one of the other officers.
Okay, Officer Sukavecki will probably meet with you after this, and she's going to give you the address for our clerk of courts.
Okay.
It's the same address as of this building. It's 500 Justice Drive, Lebanon, Ohio 45036. It's the same. It's in the same building, but your restitution payments are going to be paid through there. Now, as far as supervision fees, and I didn't go back and look what all I ordered. I did order you to pay court costs. So all of that becomes secondary to paying restitution. You know, I quite frankly, we're going to collect any amount of money that you pay towards this is first going to go to paying the victim. Okay, so until you break that $1,114 threshold, all of that's going to the victim. Then we can start working on the court costs. The community service, do you have that completed?
Yeah.
Okay, you can give that to Officer Sukavecki. Make sure they have all the information that you have. Make sure that they have the correct contact information so they can get a hold of you. Get the ICOTS transfer done for Georgia now, and hopefully you need to start making regular payments towards the restitution. Again, I don't care if it's $100 a month, but what I don't want is 3 years from now for this number to still be $4,114. You see, because then you got a problem.
Yeah.
All right. Ms. Nicholson, is there anything else I need to cover?
No.
Officer Sukavecki, anything else?
Nothing else, Your Honor.
All right, so go with her. This is just a review hearing, but to go with her, But I need you to, at the very least, start making regular monthly payments toward this restitution, okay? All right, good. Thank you.
Thank you. And Malik is in custody too, by the way. He got a
This is case number 20CR37194, the state of Ohio versus Jennifer Johnson. Ms. Johnson is before the court, as is Officer Fisher. We're here for a review hearing. Officer Fisher, has anybody been in contact with the victim in this case? Do you know?
I have not, no.
Where do you live, Miss Johnson?
Mainville.
Okay, so you're local.
Yes.
I mean, the problem we're running into now, well, we've got your probation period expires in January of 2026. Are you aware of that?
Yes.
And you have paid. Well, you've done better than most, I will say that. Did you make another payment today?
I did. I have the receipt of $2,600 that I paid today and my new updated statement of cost, which reflects the last two payments I made. So it's down to $22,000.
Okay. How close are we going to be able to get to this being completed by the deadline?
I am exploring getting a loan to pay the rest.
Okay.
And be done as soon as possible.
Okay. How much time do you think you need before you get that loan?
30 days.
Okay. Why don't we do this? Let's set this for another review with me in about 45 days, because if you've paid, once you pay this off, I'm going to cut you off early.
Thank you.
But I think maybe we ought to have the victim advocate reach out to the victims in the case, to have them at least invite them to the next review hearing. So let's do that. Let's reset this in about 45 days, and see if we can get this taken care of. And then you can pay the loan back, and then you're done with us, okay?
Yes.
All right, yeah, anything else?
No, thank you.
All right, let's do that. All right,
Can I
thank
ask
you.
one question?
Yes, ma'am.
It's been difficult to find a part-time job. When is the earliest that I could start the expungement process?
That's a good question. This is a pamphlet. There are two different ways to go. There's one's called a sealing and one's called an expungement. And this is an F4. F4 is what F4 and an F5 is what you got convicted of. So on an F4, I believe the earliest that you could seal it, I think it's 3 years following the completion of your supervision. So that 3 years will, and that pamphlet will give you that information. It'll tell you the time periods.
Okay.
But to seal the record, obviously the earlier you get off probation,
right,
the earlier that time starts to run.
Yeah.
So
I've seen the background checks that have come back, and one had showed, the full balance. The other one didn't, but it listed the charges 3 different times. I'm like, oh,
yeah,
I'm never gonna do the job.
I believe, and again, that pamphlet has updated information, but I believe that the earliest you could do it is 3 years from the completion of all of the conditions of your supervision. So that would be payment of the restitution. So even if you got off of community control in January and you didn't make full restitution, theoretically speaking, you didn't complete the terms of your supervision. And then if you come back in 3 years and say, well, Judge, I want to seal my record, I'd be like, nope.
Right.
You see what I'm saying? So it is in your best interest not only to get it paid earlier, to get the time running, but then you don't have that hanging over your head in 3 years.
Absolutely.
Okay.
I'm still raising my 2 girls. They both have graduated.
Okay.
And
But
it's been a tough road.
that pamphlet will give you that information. Okay? All right.
Thank you so
You need to
much.
talk to her?
Yeah, I'm gonna have a report down to probation.
Okay, just go down to court services then.
Thank you.
Thank you.
To allow me to get the discovery on this matter.
All right, Mr. Gonzalez, pretrial date is going to be November the 4th, 2025 at 8:30 a.m. If there's something further, have a very good day. Best of luck to you, sir.
You too.
Yeah.
Thank you, Your Honor.
Okay, thank you. Have a good day. Bye-bye.
Another person, Mr. Attorney Barrett. Is that it? She's done. All right, let's go.
We're ready on Ms. Lee, Shirley Lee.
Correct with Ms. Shirley Lee. Ms. Lee, case is dismissed. Is that correct for city attorney?
Yes, Your Honor.
All right, case, Ms. Lee, case dismissed. Have a very good day, ma'am, and best of luck to you, okay? Who else was, Chanel, Monique?
And Mr. Gales, we were ready on that one as well. Ms. Lee, your cases were dismissed.
Okay, thank you.
Let's go back on the record, Ms. Lee, have a good day. Let's go back on the record with Mr. Gales. Mr. Gales, I've given you an opportunity to speak to counsel. Counsel, what you want to do?
Your Honor, we are requesting a trial date. Mr. Gales also has documentation that he wishes to furnish to the court to bolster his claim of identity theft. And he was indicating he would be bringing that today.
All right. Well, he can, he's gonna bring it down to the court.
That's my understanding, Your Honor.
Mr. Gales, you're gonna bring it down to the court? Mr. Gales?
Yes.
You're gonna bring that down to the court, that identity theft documentation?
I will, Your Honor. Yes.
You will just have the clerk put it, Ms. Mathis put it in your file, okay?
Okay, no problem.
All right, best of luck to you, sir. Have a very good rest of your day.
Thank you. You too, Your Honor.
All right, Chanel Monique, good morning to you. What is your full name, please?
Chanel Monique Lane.
Lane?
Yes.
All right, good morning to you.
Good morning.
This is the city of Detroit versus Chanel Monique Lane, case number SP 175-45641, SP 175-45651. Appearance for the record, please.
Sherika Harris, on behalf of Ms. Lane, please state your name.
Chanel Lane. Chanel Monique Lane.
Morning to you, Ms. Lane. Today is the date and time set for a pre-trial. Ms. Lane, put you in a breakout room with Ms. Harris. She's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to the trial, okay? Join the room, please. Let's pass the matter. Trooper Feeney.
He's scheduled for 9.
Trooper Feeney, are you there?
Oh, you did, okay.
Yes, Your Honor.
Yeah, Trooper, I do have a half-hour grace period. What is your defendant's name?
I have a last name is Gibbs, first name is Tyler.
Yeah, and the issue is you came in after that grace period. I tried to get your attention.
Oh, sorry, sir. I thought it was at 9. I checked in about 9:05. I apologize.
I see that you checked in after 9:30.
No, sir. I've been in here since about 9:10, 9:05, 9:10.
No, he did. He called.
Oh, he did? Okay, very good.
I'm sorry, I was on the phone.
Very good.
Yes, did you call me?
As long as you call. Very good. All right. Tyler Gibbs is here. So, all right, we're taking them in the order that they came in, officers and I think check in at 9:05 to get you out.
Excuse me.
Yes.
Yes, what's my name? With my case card? Because I got kicked out rolling around.
No, not yet, Mr. Brown. Not yet.
All right.
Good morning.
French interpreter is zooming in. We only have it till 11 o'clock.
Judge, I'm not sure if you're on the record or the middle of it. I'm ready on Kip Gordon. Thank you.
Now let's go back on the record with Mr. Kip Gordon. Mr. Gordon, I guess just a dismissal here. Dismiss, sir, for compliance. If there's nothing further, have a very good day. Best of luck to you, okay?
All right.
City of state, strike that. This is going to be the state of Michigan versus Tyler Gibbs. Case number SX 4538502, counts 1 and counts 2. Appearance for the record, please.
Good morning, Your Honor. Wendy Barnwell on behalf of defendant Gibbs.
Mr. Gibbs, good morning to you. State your name for the record, please. Mr. Tyler Gibbs. He was here. Unmute yourself, sir. Trooper Feeney, good morning to you. Can you state your name and department for the record, please?
Trooper Feeney, badge 1284, Michigan State Police.
All right, good morning to you. Today is the date and time set for a trial/formal hearing. Mr. Gibbs, did you unmute yourself? He did.
Looks
State your
like
name.
Tyler's a girl.
Miss Tyler Gibbs? All right, something seems to be wrong with.
Yeah, you have to increase your volume on your device.
See if you can work it out.
Turn up your volume. Turn it up.
Help her, we'll put her in the breakout room. Speak to Ms. Barnwell, and Trooper, I'll put you in the breakout room.
Thank you, sir.
Are you able to hear me now?
She said something now, Judge.
State your name for the record, Ms. Gibbs.
Tyler Gibbs.
All right, go in the breakout room. Good morning to you. Go in the breakout room with Ms. Barnwell. She's gonna try to work it out for you, all right?
Okay.
Just pass the matter. All right, now would be a good time for me to go downstairs. Any other counselor? Attorney Broderick, are you still here?
Yes, sir. On Oliver.
Tracy Oliver is here. City of Detroit versus Tracy Lynn Oliver. Case number SP 1707776, counts 1, 2, and 3. Appearance for the record, please.
Good morning, Your Honor. Matthew Broderick appearing on behalf of Miss Oliver. My bar number is 47403. Your Honor, I spoke with Ms. Schneider and verified compliance with the underlying offenses in terms of registration, insurance, and tinted windows, and she's agreed to dismiss the matters.
Officer Ford, good morning to you.
Good morning, Judge. How are you, sir?
Very well. Did you hear that?
Yes, sir.
Name, badge number, department for the record, please.
Yes, sir. Officer J. Ford, badge 512, Detroit Police Department.
All right, I'm going to dismiss the cases for providing valid documentation. Tracy Oliver, good morning to you. Can you state your name for the record, please? Tracy Oliver was here.
She was, Judge. She told me she was having some technical difficulties with getting on. I think she may be watching you on YouTube.
Yes, I'm here. I'm off mute now. They just let me in.
State your name for the record, Ms. Oliver. Good morning to you.
Good morning, Tracy Lynn Oliver.
All right. Case is dismissed, ma'am. Have a very good day. Best of luck to you.
Thank you.
All right.
Thank you, Your Honor.
You should have mentioned that earlier. I would have got that on the record long ago. All right. Be safe.
No, I was very impressed watching you move the docket, Judge.
Thank you. Thank you so much. Officer,
have a good day.
Out there, Ms. Oliver and Council Broderick, be safe. Have a very good day, all of you.
Thank you. You
I
too.
appreciate you, sir. You too. Thank you.
Your Honor, I apologize for butting in.
Yes.
I'm waiting on to be put into a breakout room with Mr. Leak.
All right. Didn't I give you permission or
I got dropped. I lost Wi-Fi, so I think I'm still a participant. Thank you.
Room 8.
Thank you.
All right, very good.
Good morning, Your Honor, to you and your staff. I'm the French interpreter. They just called me in.
All right. Here's the bonjour, Mademoiselle Ghana. Gentlemen, what's your name?
For Mr. Lou. Monsieur Lou?
Oui, ça va?
What is that? Comment vous appelez-vous?
Je m'appelle Michael Lou.
Michael Lou.
Yeah.
Michael Lou. The last person where?
On page 2.
On page 2. All right, Ms. Ghanem, good morning.
Yes.
Can you state your name for the record, please?
Tanya Ghanem.
Does he have a device he can sign on to?
Can you hear me?
Ask him, does he have a device he can sign on to, please?
Yes, Your Honor.
Do you have proper documentation, sir? Sign them off, please. Ms. Ghanem, can you raise your right hand, please? Do you swear or affirm to tell that you will truly, accurately, and impartially interpret in the matter now before the court, not divulge confidential communication, so help you God?
I do.
And do you swear or affirm that to the best of your ability, you'll interpret from English to French and French to English?
I do.
All right, very good. Is there a lawyer here?
I'm sorry?
Not yet. Let me go back. Let me pass it momentarily. Get him signed on. We'll get him in the breakout room with an attorney as soon as the attorney comes available.
Yes,
I'm gonna pass it and wait on an attorney to come out.
Okay, so he's not
Oh, no,
here?
sir.
Or-
He's here. He's here. We're getting him signed on, and we're getting an attorney. We'll get him an attorney, and we're getting him signed on to he's in the courtroom.
And
Stop leaving evidence in here.
All right, let's go back on. Hold on, Lozier. You have to mute yourself. So let's go back on the record with Mr. Owens. Mr. Owens, I've given you an opportunity to speak to counsel. Counsel, what is your client? Your client's going to take a plea?
Yes, Alan Soroki, P37441, appearing on behalf of Mr. Kenneth Owens. He's accepting the offer of the prosecution. He'll be pleading guilty to 2 charges of failure to leash, and the remaining 4 counts will be dismissed.
Is this under a delay?
Under a 12-month delayed sentence, that's correct.
Mr. Owens, are you there?
Yes, Your Honor.
All right, you want to take the deal?
Yes, Your Honor.
Raise your right hand, please. Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
I do.
All right, Mr. Owens, Mr. Brooks, are you there? Where's Mr. Brooks?
He's still in the waiting room, Your Honor. The breakout room.
Is Investigator Charleston here?
Yes.
Let's bring Mr.
Yes,
Brooks.
this Investigator Charles.
All right, good morning to you. So, Miss.
Got some things wrong about this.
All right, Mr. Owens, these dogs. I mean, what is going to be done? Mr. Owens?
Your Honor.
Yes, Your Honor. I couldn't hear you say.
Yes, Mr. Soroki.
Your Honor, Mr. Owens, he intends to, the good thing is the dogs are not vicious and haven't bitten anybody. He has to do a better job of keeping them on his property. And the animal control is going to go on, visit with Mr. Owens and show him how to do that.
Well, listen, you don't know the history of this, or I don't know if you've learned the history of this. This is a case, this is the second time that these gentlemen have come before me. And, Mr. Owens, you made it, you make it appear that Mr. Brooks is being unreasonable. And that's how you made it appear the first time. And the cases were dismissed, I believe. I believe that was the action.
No.
They weren't dismissed, so you pled guilty the first time, is that correct?
Yes, and I paid my fines and costs.
I know that. And now you're pleading guilty again. But my point is this, is that you're making it appear that Mr. Brooks is the one that is the problem. Now, I tried to get you guys to resolve this amicably. You are neighbors, or I know it is an issue of somebody maybe not living there or something like that, if I recollect before. But if Mr. Brooks owns the home next door and he owns the home next door to you, or if he's renting, or regardless of where he stays or what, if that home is in his, just let me finish. If that home is in his name, or he has a right to be there, then don't you feel that he has a right to not have your dogs intrude on his property?
It's a legal law. That wasn't me you was telling hold on. That was someone else.
Yeah. I'm sorry. Yes, Bishop. All right. Go ahead. So I hope that you can get this together so we can not have these issues. I mean, really is something that grown men should be able to talk about. That's what all it is.
That's what you would think, but unfortunately it's not, Your Honor.
But again, this is the second time, Mr. Owens.
They dogs, Your Honor. They dogs, Your Honor. I mean, I'm only human. I own up to all my mistakes. If it's my fault, it's my fault. I'm not about to argue about nothing that's my fault. But at the end of the day, they're dogs. Dogs, it's like telling a kid not to be a kid. Like, my dogs have never bit nobody, never chased nobody, never harmed nobody, never foul played nobody, never destroyed nobody else's property, never done none of these things.
Yeah, but they defecating on my property.
Stop
and
it.
tearing up my fence.
I didn't ask you to speak, Mr. Brooks.
Sir. Listen.
I did not ask you to speak. Mr. Owens, you're missing the point. You're missing the point. They're dogs, right? But if you're a dog owner, you got the responsibility. I have dogs. It's my responsibility to keep my dogs on my own property. And no matter what anybody else says or my neighbor, they probably hate dogs. They're probably afraid of dogs. They probably love dogs, but don't, again, like Mr. Brooks says, don't want them defecating on their property, or just don't want them on their property at all. Can you respect that?
Yes, like I said, I do.
All right, that's what the point is. So by you saying that they're dogs, they're just dogs, you're still trying to limit your culpability in this. And I get it. Your dogs aren't vicious. Your dogs aren't harming anybody. I get it. But you have to sit back and look at the other side. You have to do that. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines? Mr. Owens?
Say yes, Your Honor.
Do you understand that you have an absolute right to a trial?
Yes.
Mr. Soroki went over your other advice or rights in the breakout room. Did he not?
Yes, he did.
And you understood those rights?
Yes, I do.
Do you have any questions about those rights?
Not at all.
Do you know by taking this deal, you're going to give those rights up?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No, sir.
All right. Let me draw your attention back to March the 10th, 2025, at around 2:30 p.m. in the city of Detroit on the Monte Vista Street. Did you own some dogs on around that date and that time, sir?
Yes, Your Honor.
And did those dogs get out of the yard and were unleashed?
Yes, Your Honor.
All right. Is that satisfied? Satisfied, Counselor?
Yes, Your Honor.
All right, the court is satisfied. And was that two different dogs, or was that two different occasions? That same dog?
Same dog, I believe.
Let's see. Officer Charleston?
Yes, it's Officer Charleston.
Is that two different dogs or the same dog? Got out of that property twice on that day?
Can you repeat that date again, Your Honor? I'm looking at my report now.
March the 10th at 2:30 p.m.
I'm looking at my report now.
Alexis Schneider for the People, P80322. I believe, Your Honor, there were two dogs on at least two separate dates. I would defer to the court or to Mr. Owens on which you'd like to plead to on the different dates or on the two dogs. Either would satisfy.
Well, I was talking about the it appears that either the same dog got out on the same day, or two different dogs got out on the same day. But I have two dog restraints on the same day at the same time. So same dog can't get out twice. Well, it could, but not at the same time.
Yeah, so then that, if it's showing two, then that will be both of the dogs.
All right, will you admit to both of the dogs getting out of the property on the same date, Mr. Owens?
My claim was misidentified.
Mr. Owens.
Excuse me, Your Honor. I couldn't hear
Will you
you.
admit to both of the dogs getting out on this property on the same date?
Sure.
Okay. With that, I'm gonna find you guilty of the amended, as charged to the dog restraints, 2 counts. Specific probable cause to dismiss the other matters.
If you let, Your Honor.
All right, if this doesn't get it, 240 for both of them, 480, $480. If that doesn't get it to get you to make sure these dogs get restrained, it's gonna get awfully expensive for you. When can you pay it, sir?
I can pay that whenever, Your Honor.
Well, pay it today.
Sure, no problem.
Okay, all right.
I love to help myself.
I'll give you, I love animals too. I do too, but you have to keep them onto your own property. Pay it by, make sure it gets here by tomorrow. I'll set the matter for review at 8:25. Pay it at any DivDat kiosk in the city of Detroit. I'm told you can upload the DivDat app to your phone. If it's paid and you confirm that, then we'll dismiss the case. You don't have to show back up. But if you want to see it through tomorrow, come at 8:25. If it's not paid, I do need to see you. I don't know what else to say.
Your Honor, I'll have it paid before the day is out. It's nothing.
Okay.
Your Honor, I object to an early closure of the delayed sentence. It's supposed to be 12 months, just to ensure compliance.
I'm sorry, 12-month delayed sentence, 12-month delayed sentence. Give me 12 months.
Be 8/21, 2026.
So I still have the fines and costs. I still got to pay the 480.
Yeah, you have to pay the 480, but you have until next year to pay it, and then you won't. It'll come back on the 21st?
Yes.
Of August 2026. If there's some more issues with these dogs getting out and you plead guilty to that or found guilty, then you're gonna lose the delayed sentence and they're gonna stay.
That's for anything that happens after today, right? Not anything prior to today, right?
Right.
Exactly.
You've got to understand how the law works. So wait a minute. Are we saying the dogs got out again?
Man, Your Honor, I don't want to talk about it, man.
All right, man.
I don't want to talk about it, man.
You got a good client there, Mr.
I don't want to talk about it.
But it sounds like you may be representing him again. All right? Or somebody.
It's crimes, though, man. I ain't gonna lie, man. I got 3 businesses, man. Them peanuts. I appreciate y'all, though. Y'all have a blessed day.
I do. All right. Be safe out there. Have a very good rest of your day. Mr. Brooks, if there's nothing further, sir, best of luck to you. And have a very good rest of your day.
Good day to everyone.
All right,
Your Honor.
Yes, Ms. Barnwell.
Okay, so Your Honor, there's no offer made on Tyler Gibbs, and I'm thinking maybe it's because it's a state case. However, she did show me insurance on her new car, so I don't know if the city attorney is involved in this ticket.
I guess we're gonna go back on the record with Ms. Gibbs. Ms. Gibbs, go ahead, make your record, Ms. Barnwell.
Yeah, good morning once again. I'm Tyler Gibbs. Ms. Gibbs showed me insurance from Cure Insurance on a 2004 Honda, which is admittedly not the car. The other car was
Understood. All right, Miss Schneider, can you put your appearance on the record, please? Is Miss Schneider there? She's in the breakout. Officer Trooper Feeney.
Yes, sir.
All right, any objection to dismissing because she does have valid insurance now?
No, I talked to the city attorney. I would be good if she had insurance now, but the VBSL will stand if that's okay. That would be my offer.
Talk to the, all right, so And what is that? The basic speed law, basic speed law. All right.
The violation of the basic speed law too fast for conditions.
All right.
Oh my
So
goodness.
there's the offer. Go ahead. What's the issue now?
So the issue is it involves a person who was trying to get away from another person who was about to hit them, coming into their lane, her swerving and hitting the wall.
So, I mean, basically you're saying she's running from somebody, right?
Yeah, somebody came into her lane suddenly and she had to move over. So she moved over and hit the wall.
Go talk to Trooper Feeney about it. Go talk to Trooper Feeney about it. Go talk to Alexa Schneider about it again and see if you guys can work this out. All right. Go back in the breakout room and see if you can work it out. All right.
All right. So I got to see which room then. Okay.
It's on 4, 6 and 4.
Okay. Thanks.
All right. Very well. Pass the matter. All right. Let's go back on the record with Miss Monique, Miss Chanel Monique. Lane, cases are going to be dismissed. Is that what you're saying, Miss?
Yes, Your Honor, that is the recommendation.
Even the failure to stop at a stop sign?
Yes, Your Honor, that was the recommendation by the city attorney.
All right. Case is dismissed, ma'am. Best of luck to you. Have a very good day.
Thank you. You too.
All right, you're welcome. All right, let's call it. This is the city of Detroit. This is an interpreter case, Miss Harris. This is the city of Detroit versus Mbaki Low. Case number SP 174-51981. Appearance for the record, please. Go outside.
Oh, go outside. Go outside.
Oh, put him on.
He's on. He's on.
Dites ton nom.
Go ahead, Ms. Down.
Yes, Your Honor. Dis votre nom, Monsieur Lou. Monsieur Lou. Oui. Dis votre nom, s'il vous plaît.
Je m'appelle Michael Lou.
Michael Lou.
Sherika Harris on behalf of the defendant.
Sharon Heffett est votre avocat.
All right. Okay. Time set for pre-trial, Mr. Lowe. I'm going to put you in a breakout room with Ms. Harris. She's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial.
Elle va te mettre dans la chambre avec l'avocat. Et si tu n'aimes pas l'offre, on va revenir un autre jour. Your Honor, I do have a funeral at 11:30. Do you think I'll be done by then?
I think so. Yes.
Okay.
All right. Join the breakout room. She's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial.
Maintenant, sur votre écran, appuyez sur le join. Join breakout room. Did he go, Your Honor? Did he join?
Yes, he's in there.
Okay, I need to. Yes.
Yeah.
Thank you.
All right, this is the city. Let's pass that matter. This is the city of Detroit versus Otis Lee Graves. Here you go. Case numbers SP 169-83341, SP 169-83511. Appearance for the record, please. Is there an attorney here, Mr. Berry? Appearance for the record, please, for Mr. Graves.
Otis Berry Jr. on behalf of the defendant. State your full name, Mr. Graves.
Otis Lee Graves.
All right. They have date and time set for a pre-trial. I'm going to dismiss the cases for providing valid documentation. Mr. Graves, there's nothing further. Appreciate your patience. Have a very good day. Best of luck to you. All right.
Yeah, thank you, Judge.
But I do have a ticket where I had to pay $145. The ticket related to this case.
I got it.
Okay, thank you, sir.
All right. Best of luck. All right.
Can we get a couple minutes before we go to the next one, please?
All right, with that being said, I'm gonna go downstairs and I have to take care of the felony docket. Mr. Dupree, I see you there. Who's your client, Mr. Dupree?
Judge, I have Alexis Green. It's a dismissal.
Miss, are you there? No, yes.
Alexis Green, are you there?
No, as Miss, I think she's gone.
Yes, I'm here. I'm sorry.
No, I'm talking. Good morning, Miss Green.
Good morning. How are you?
All right. Unfortunately, it's not gonna take me long. I don't see how they're gonna be dismissed though, because, I'll say you, okay, very good. All right, it's not gonna take me long. I'll let Miss,
Your Honor.
Williams Law know. I mean, that she's taking a break anyway. Okay.
Excuse me.
Miss Harris, I see you, Miss Lockridge. You're in line.
Your Honor, I was
All
just asking if you could view his document because it's on his phone rather than him going to his car.
Yeah, that's what he's trying to show. All right, let me. Swipe to the left for insurance. This is an improper plate anyway. I think Ms. Harris is Ms. Williams Law has stepped up.
Excuse me, Judge Perkins.
Good morning to you, Mr. Gervin Barnes, again.
No, sorry about that. My phone overheating and it keep taking me out of the courtroom. Set the temperature too hot, so I can't even see the court. I don't even know if you called me or not.
No, not yet, sir.
Maybe he should call in.
Maybe you should call in. I know what you look like. Or maybe you should just hang up for a few minutes and zoom back in. You won't lose your spot, all right?
All right.
If his phone overheating, he probably should call the phone to line. All right. Yeah, you call back in and stuff. Let me go downstairs since Miss Williams Law is taking a break. All right.
What's the phone number?
The phone number is 929-436-2866.
929-436-2866.
Yes, sir. You can go off of the Zoom and call, and you'll connect you to.
Yeah. And I'll see him. I'll bring him in.
And it'll connect you to the clerk.
For the second, connect you to Zoom, and then I'll see your phone.
Excuse me, Judge. I'll be able to do the same thing. I got a bad connection.
Are we not trying to have everybody on Zoom? Just wait till the judge come back.
Court is in recess.
Yeah, just try not to answer any calls or text messages while you're on Zoom. Because what it'll do, it'll boot you out as well.
Court is in recess. Mute your phones.
You got
Kenneth Gibbons.
The court is now in recess, okay?
Oh, okay, but I've been waiting since 8:30.